Kristen House case.
All right, so we're on the record in docket 25-01590. That is people of the state of Michigan versus Kristen House. Will the parties please introduce themselves for the record? Mrs. Al.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Carter.
And please the court, David B. Carter Jr. on behalf of Ms. House, who is present and standing at council table.
And ma'am, you are Kristen House, is that correct?
That's correct.
All right, thank you. This is the time set for a final pretrial in this matter. Mrs. El, how we proceed?
Your Honor, at this time, the people's necessary witnesses have failed to appear. They were subpoenaed for today's date, and we have had contact with them in the past regarding this court date and this case. We are not sure why they are not present today. We do expect a motion from the defense.
All right, thank you. Mr. Carter, motion.
Thank you, Your Honor. Your Honor, typically I don't make motions when witnesses fail to appear at the first time that they don't fail to appear, rather, but in this case, my client maintains her innocence and she believes that perhaps the witness isn't showing up because the case isn't as what it is described to be. So with that record, I'd ask the court to dismiss this case without prejudice.
All right. And Mrs. L, the complaining victims and witnesses were subpoenaed. You've had some contact with them, and then they failed to appear today.
Correct, Your Honor.
All right, I'll entertain the printing of the dismissal without prejudice. So Ms. House, it's been explained to you, this is a motion dismissed without prejudice, which means the people could reissue if they choose to. But today, the default, the realistic purpose is the case is dismissed. All right, ma'am? Right, I'm in possession of the order of acquittal or nollie pros on 25-01590. And based on the defendant's motion, I will sign the dismissal without prejudice based on the fail to appear the complaining victims.
Your Honor, I believe there's also a box on there to check to clear up her record. Is that correct? I'd ask for that box to be checked. I think it's 6. May I approach?
Yeah, I just have defendant juvenile shall immediately just be discharged from confinement.
It's box 10. I'm sorry.
Oh, any type, that's fair. Any type of fingerprints or biometric data that's taken by the Michigan State Police is to be dismissed. That's usually not an issue in 54A, but in 54B and others, it can be an issue. All right, but I'll check box 10 in that regard. Ma'am, you are not on a tether. You are with a no contact order. So I would keep this. We'll give you a copy of this. You could keep it with you because it's going to take about 3 or 4 hours to purge it from the system. So just to protect yourself. Anything else for the record in 25-01590, Mrs. L?
Not for the people.
Mr. Carter?
Not for the defense.
All right, thank you. Well, you can get a copy from my code officer.
Thank you.
Thank you, Mr. Carter.
Your Honor, we are ready on that motion hearing in the Junior Silva case.
Is that Silva Silva Castaneda? That's a great question. Let's see.
I know I ordered one.
We have an interpreter here for Castaneda Silva.
I'm not sure.
Judge, I don't believe our client is here.
Okay.
And we'd be happy to waive his presence for today's hearing. It's just a motion. It's not a dispositive motion. So I think we can waive his hearing or waive his presence if the court's comfortable.
My real concern is that we ordered it. We've had some problems. We've ordered a Spanish interpreter and one is not present. And so, and there was a Spanish interpreter arraignments. and then we ordered Spanish. That only becomes a thing because, not because we can waive the presence of Castaneda Silva, but we've been ordering the Spanish interpreter and then they don't show up. And then we've got concerns whether we can go forward or not. I don't think it's a problem with this hearing, but it could be a problem with the plea or something else.
We have a sentencing I scheduled at the same time as that.
All right. So that's USD De Leon, correct? All right. But if Mrs. L, if you don't have a problem waiving the appearance of Silva, this is not that type of motion, then we'll go forward on the motion. I don't think we can go forward on the sentencing until the interpreter's here.
There shouldn't be a sentencing, Your Honor.
Not on this case, but on US De Leon there is.
Oh, correct.
Yes.
And I think we ordered an interpreter for that case. Let's see.
Okay.
Spanish interpreter was one.
Your Honor, regarding that case, I have checked. Mr. De Leon has not appeared yet. My thought may be that because the
Nobody's
notice-
coming to court.
Well, my thought may be that since the notice he originally got
Right.
was for the 1:30 time period, and I believe the other notice was mailed to him, I'm not certain whether he may have gotten the new notice. He may still be under the impression he needs to be here at 1:30.
All right. So we'll wait and see on that one. So let's go on the record in docket 23-03066. That is People of the State of Michigan versus Yunar Castaneda Silva. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Lizal, Assistant Prosecutor for the People.
Mr. Foreman, isn't it?
Yeah, thank you, Judge. Jonathan Foreman, Office of the Public Defender, here to argue this motion today on behalf of Mr. Silva. Also present with me is James Harris from my office.
All right, thank you. Mr. Harris, you can state your appearance.
Assistant Public Defender James Harries here on behalf of Mr. Junior Silva, who is not here today. My understanding is that we are going to be waiving his appearance.
All right, and this is, we're waiving the appearance of Mr. Silva so we can go forward.
That is correct, Your Honor.
All right. So this is a motion to prohibit use of the term victim. First of all, is there any objection to the motion?
Yes, Your Honor, and the people would object to the motion being granted. We would ask that the motion be denied.
All right, thank you. So we'll entertain the motion from Mr. Foreman concerning the prohibition of the use of the term victim.
Thank you, Judge. And if I may approach, there's actually some recent Court of Appeals case law.
Absolutely.
I provided this to the prosecutor as well.
Thank you.
So, Judge, what I've just handed you is a concurring opinion, admittedly from back in May, a published concurring opinion from Judge Schwartzel at the Court of Appeals, where he concurred in an opinion that denied essentially the argument that I'm making here today in the CSC context, based on presidential case law at the Court of Appeals, that specifically in the CSC context, where there's different elements of play and where the legislature has defined a victim as including an alleged victim specifically. This was my argument in that case was denied by the Court of Appeals, but Judge Schwartzel did highlight some, I think, really important contradictions with the people using the term victim in front of a jury, especially when the defense is denying that anything occurred at all, or where the defense is acting in or is claiming that the defendant acted in self-defense. This is one of those cases here where if this case proceeds to trial, our argument is going to be that actually nothing occurred. Certainly nothing assaultive occurred. And in that context, Judge Schwartzel points out that there's a huge contradiction in the people being the representatives of the government proceeding as if the question of fact has already been answered. Where if the people are saying that this person is a victim, which means that there's a perpetrator being a defendant and the victim being the person on the stand speaking to the jury, then that's the people, the government taking the question out of the hands of the jury and instead saying, no, actually, here's what happened. The government has already decided what happened. You're just here to check, to rubber stamp that. And I think it provides some real, it requires some real thought and some real pausing, because I know every legal professional, especially all of us in this room, use the term victim routinely. And there might be something where we have to rethink our vocabulary as well. But when it comes in front of a jury who don't have the day in, day out conversations that all of us in this room have, we should have some thought and we should really have some pause about using that term victim in front of the jury. What Judge Schwartzel pointed out is that the prosecutor's use of the label victim is a signal to the jury that, at least in some sense, the public has found this complainant to be, in fact, a victim. Judge Schwartzel says that the use of the term victim in front of the jury is illogical, unnecessary, and prejudicial, especially where the actus reus is in question. There's case law that we've cited in our brief from all throughout the country supporting our position. I understand that the case law in Michigan is not in our favor right now, but there also seems to be, between this Judge Schwartzel concurring opinion, there's a unpublished opinion from a couple of weeks later where the Court of Appeals is specifically requesting the Michigan Supreme Court to take up this question and resolve it once and for all, one way or another. But there seems to be a groundswell moving against using the term victim in front of the jury, specifically for these reasons. The Judge Schwartzel opinion cites a lot of the same case law that our brief cites that we presented to you today. So we'd ask that the court not allow the use of the term victim if this case does indeed proceed to trial. Just a couple of notes on the prosecutor's brief, which we did receive late yesterday, Your Honor. Want to make sure you received it as well.
Let's see. I don't know if I received the prosecutor's brief on this. But you may respond. I don't think I have.
Understood.
Prosecutor's brief on this.
Thank you, Judge. Just a brief note, the prosecutor begins their analysis by stating that the prosecutor's role in a criminal proceeding is to advocate for the victim and the theory of the case they are presenting to the jury. As the defense, we have an entirely different view of what the prosecutor's role is. And I think the court system has an entirely different role of what the prosecutor's role is. The prosecutor isn't here to advocate for the victim. The prosecutor is here to advocate for the people of the state of Michigan. And as Judge Schwartzel points out, the prosecutor's responsibility to the court and the public is first and foremost that justice be done, even if that means losing a particular case. And where the prosecutor views their role as advocating for a person, as opposed to advocating for the people, I think the prosecutor loses view of what they're here to do. And so I would just point that out in response to the prosecutor's brief, Your Honor. We would ask that the court grant our motion and disallow the use of the term victim if this case doesn't, in front of the jury, if this case does indeed proceed to trial.
All right, thank you. Mrs. L responds.
Thank you, Your Honor. And to clarify, Your Honor, I did send this brief at about 3 p.m. I did submit it to the traffic and criminal division of the court. Unfortunately, it sounds like it has not yet made its way to the court from that email address. The defense is correct. However, I did state that in my brief. I did state that the prosecutor's role is to advocate for the victim, and that was a misstatement. Our job here is to advocate for justice, advocate for the people of Michigan. However, that does not limit our ability to use our case theory and to present a case theory that fits the case, that is the best, that represents our theory of the case. In order to properly present the theory of a case, we need to be able to use words that the jurors and normal people in everyday life would be used to using. Specifically, when we're presenting witnesses such as officers who may not know the victim's name or the complaining witness's name, it would be easier for them to say the victim in this case, the person who came to us saying that there was an assault that happened. That would be easier for the officer to convey what role that person was playing during their investigation. With that being said, Your Honor, the defense came up and said that nothing occurred. That's their theory of the case. Well, if that's their theory, why can't we say that something did occur? And actually, that is what we do. We come in every single case, especially assaultive cases, and say something did occur. In fact, an assault occurred. Something assaultive happened. And when something assaultive happens, it is common, it is normal for everyday people to assume there is a victim. And it is part of the people's case, it is part of the people's accusations that there was a victim. And it is part of our job to support the use of the word victim with supportive evidence of that assault and that our victim was the one who was assaulted. Your Honor, I believe that this is not an unfairly prejudicial use of the word, as there are many safeguards in place, including jury instructions. There are safeguards in place in closing arguments. There are safeguards in place throughout the case objections that can be made by defense counsel to prevent any undue prejudice in this case by the use of the word victim. If the use of the word victim does present any potential risk of prejudice, it's the court's job to then weigh it against the probative value. And it's only if that prejudicial value outweighs the probative value that it should be prevented from coming in.
Actually substantially outweighs, correct?
Yes, Your Honor, thank you for the correction. And Your Honor, the Michigan Supreme Court has yet to find that the use of the word victim substantially outweighs the prejudicial, the prejudicial effect substantially outweighs the probative value here. In fact, in the concurring opinion that defense relies on today, where is it? Sorry. Fourth to last paragraph, Justice Swartzwell says, following the rules set down by the court in our Supreme Court, and then at the bottom, until this court's bound by precedent, they are bound by precedent to permit the practice of the use of the word, as they have not yet found that it's unduly prejudicial to defense. At this time, Your Honor, we would ask that the motion to preclude the use of the word victim be denied.
Thank you.
I can respond briefly, Your Honor.
You may.
Thank you, Judge. The prosecutor speaking in terms of 403, we actually raised this as a due process issue, a right to a fair trial issue. So the balancing test of 403 in terms of whether it's probative versus unduly or substantially prejudicial doesn't play into account here. We're making a due process, a basic due process, basic fairness, right to a fair trial argument. The defense would have no objection to the use of the term alleged victim, which is something that common everyday people can understand and something that police officers certainly understand. And you know, I'm just going to note that the prosecutor mentioned that this wouldn't be unfairly prejudicial. That was the terminology that she used.
Right.
It kind of acknowledges it's implicit. There's kind of an implicit acknowledgement there that it would be prejudicial to the defense, just not unfairly prejudicial. I think that kind of animates this whole conversation we're having. The prosecutor wants to use the term victim at trial and is objecting to the use to our motion and objecting to having to use different terminology because the prosecutor wants to imbue in the minds of the jury that this person is a victim. But that's the prosecutor's job to prove, and that's the jury's job to decide. It's not something that the prosecutor gets to say out front, this is the case. So for all that reason, we're asking the court to grant our motion.
Thank you. As both parties aware, that I understand the case law in Michigan. I understand the persuasive case law outside of Michigan. And then I've tried a billion of these cases, not a billion, but a lot. So I've kind of developed my own theory concerning, and that's as a prosecutor and then as an academic. And so I've kind of, and this, of course, is not the first time this motion's ever come forward. I think I've answered a few questions, answered a few motions like this. I think that the defense raises a good point. Okay, and I think that the term victim can be polarizing. I think that can be a polarizing term. That being said, during trial, and this is a DV, so it would be during trial. That is that's the issue I have. I have an issue that during trial, if a jury were to hear that, depending on the explanation, it's only an alleged victim until conviction. That's the problem. Okay, and so this is my ruling, and then you can take the appellate court and whatever. But I think that the prosecutor can use the term victim in opening statement, which is a preview of the evidence, if the prosecutor explains why they're using the term. So they're using, the prosecutor can say, we are calling this person a victim because they were essentially the alleged victim of the assault, or they're the victim of our advocacy, which is that they were assaulted on this matter. That's just a preview of the evidence, what we sincerely believe the evidence is going to be. During the actual trial, I do not believe we can refer to the victim as a victim. I think it has to be an alleged victim because the proofs haven't come in concerning whether the assault has occurred or not. And so during the trial, so this is where law enforcement, who's not a lawyer, so the victim or the alleged victim of Orquídea Hernandez has to be indicated as the alleged victim by law enforcement during the trial itself, during their testimony, because she's just an alleged victim. I know it's going to be hard because they're going to refer to her as a victim. There's going to be an objection. There should be objection. And then we'll clarify she's the alleged victim at this point. She's not a complete victim because there's been no conviction. That actually is the decision of the jury to make. The jury has to determine that she has actually been assaulted. And we don't have that decision yet. So I don't think we can call her the victim. She's just an alleged victim. Now, closings, we know, is just rebuilding what we've already seen. So I think in closing, you can call it the victim. You can call it, if you think somebody's lying, you can call them a liar. If you think somebody's not telling the truth, it can be mistaken. All gloves are off concerning closing if the evidence fits what you're closing. But I do think that during the trial itself, it's improper to say that that's the victim, because that connotates that that's the person who indicates was the victim of an alleged assault. And that's only an allegation at this point. That's not really the confirmation. The decision, the jury has to make that determination. So I think an opening statement, as long as it's explained in closing argument, both sides can argue what the evidence indicates. But during the trial itself, I think it can only be referred to as the alleged victim or by name, which is kind of my preference, is that the person who is labeled Orquídea Hernandez, that's her name, that is enough to explain. But I'll leave it to counsel, and I know it's not easily done. We do get in a vernacular of saying these things, and so that'll be your instruction to law enforcement is you've got to call her an alleged victim or by name, or we'll entertain an objection. Mrs. L.
Thank you, Your Honor. I would like to ask for some clarification as to how to offer that to the officers without it being.
You can blame me.
Coaching.
So you can indicate that the judge has ruled that you can call her the alleged victim, or you can call her by her name.
Okay, thank you, Your Honor. And additionally, Your Honor, I would just like to clarify that the victim's name is Roxana Hernandez. We did make a motion in prior court dates to have that amended.
Yeah, I have Orquídea and it's Roxana.
Correct,
Yes,
Your Honor.
that is correct, Your Honor. There was the previous motion to amend the complaint to include the.
And I have that on May 6th, you amended to Roxana, which would be an indication so however you want her referred to, but they should refer to her by name or alleged victim. Any questions concerning the ruling of the court or clarification, Mrs. L?
No, Your Honor, thank you.
Mr. Foreman.
We can prepare an order, Judge. So just to clarify what the order should say, that the term victim can be used during argument if the prosecutor explains that that's their theory of the
Opening
case.
statement, yes. Yep.
During opening statement, it cannot be used during proofs during the
During
trial
proofs,
itself.
it cannot be used.
And it can be used during
Yes,
closing
and then
argument.
closing argument, as the gloves kind of come off, so.
Your Honor, we would ask that the proposed order does include the clarification that alleged victim can be used,
Yes,
as the word victim itself is now being
Yes.
singled out.
and you'll get to review the order and then we'll submit it to the court for the court signing.
Thank you, Judge.
Thank you. All right, anything else for the record in 23-030-66, Mrs. L?
Not for the people.
Mr. Foreman.
I don't believe so, Judge.
All right,
Now,
you're all set,
myself,
thank you. Yeah, that's, all right, next week. Do we have a Spanish interpreter here? Is Francisco de Leon here?
No, my understanding,
Let's-
my assumption, Your Honor, might be that he's operating on the original. court.
Right, well, let's wait till 1:30, but we don't know if we need.
When I sent a new notice, I highlighted
Yeah, my concern, Your Honor, is that given that he doesn't need the interpreter and doesn't exactly
Right,
understand English, I realize numbers may be different, but
right, that's a problem. B, we still have no interpreter for either case that we ordered an interpreter on, which becomes a problem later. This is an ongoing problem that we,
I emailed Ms. Barber, who handles our interpreter, but I know that she's probably doing jury line right now.
so let's wait till this afternoon for the De Leon case to see if he shows, and then maybe in the meantime, we can get Carlos,
Yeah.
yeah,
that's-
in the afternoon with
And I know
some,
Gus is here.
okay, and Gus is.
the one line. Trying to get the assessment from. so that you can just go, "Oh, you should have talked about the assessment, but you should do it. Please fill out this one."
Alright, let's go ahead and call some of these then, so.
Are you Stephen Woody, sir?
Yes, sir, I am.
All right, I'm gonna place you in your breakout room with your public defender we're gonna call a couple of cases and I'll place you to talk to him, all right, sir?
Yes, sir.
All right, let's go with Mr. Woody. All right, so we're on the record in docket 25-01443. That is people of the state of Michigan versus Stephen Woody. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. McLean.
And
Your
sir,
Honor, can I ask for clarification? Which case are we calling?
this was Stephen Woody, I thought.
And this is Mr. McLean. Mr. Woody is
Let-
in custody, Your Honor.
That's right. That's my fault. Let's go on Mr. McLean. Sir, I put Mr. Woody aside. All right. So we're on the record in docket 25-01198. Thank you, Mrs. L. 25-01198. That is people of the state of Michigan versus Christopher McLean. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. McLean, who is standing to my right, Your Honor.
And sir, you are Christopher McLean,
Yes.
is that correct?
Yes, sir, yes, sir.
Thank you. We're all set on this file. Mrs. L, this is a pretrial. How are we proceeding today?
Your Honor, it seems that there's been a little bit of difficulty receiving that license. So at this time, the people have extended an offer of a civil infraction of breach of the peace. And I'll defer to Mr. Harris.
Mr. Harris.
Yes, Your Honor, I spoke with my client regarding the dog license. He was originally planning to go to the dog license and the dog vaccination clinic on, I believe it was July 9. However, he had a bit of a family emergency with his medical emergency with his son he takes care of, and the money he had planned to use for that dog vaccine clinic ended up having to go to the bills for taking care of his son. He did indicate to me he was planning on going to the dog vaccination clinic on, I believe, the 21st of next month. When I spoke with that with the prosecutor, there was concerns about the court setting it out and being willing to set it out and that far again, given that it's already a final, given that it's.
We're two pretrials.
Yeah,
in.
so
Completely
it was
understand.
at this point that the prosecution and the defense came to the agreement on the breach of the peace civil infraction. I did discuss that with my client yesterday, and he indicated he would be willing to accept responsibility for the breach of the peace civil infraction.
Breach of the peace, the fine is
150.
150.
Yes, and I believe he was requesting, I
Sometime.
believe he was requesting 60 days, Your Honor, to get that paid.
All right, and you'll be accepting responsibility for the civil infraction on behalf of Mr. McLean.
Yes, Your Honor.
All right. All right, just so we're working from the same ticket, this is for conduct which occurred on April 17, 2025 at 1412 Lincoln in the city of Lansing, and you accept responsibility for Mr. Christopher James McLean for being in breach of the peace on that date. Is that correct?
Yes, Your Honor.
All right. So we'll have the fine, that breach of the peace civil infraction comes with a $150 fine. We will dismiss the underlying misdemeanor. And I'll take a date 60 days out for payment.
No.
All right, so as Mr. Harris probably indicated to you, but for the paper, you can pay online, in person, or by phone. It's $150. You have till September 22nd to kind of set up your own plan.
Yes.
As long as it's all paid by September 22nd. Anything else for the record in 25-01198, the misdemeanor, the underlying unlicensed dog misdemeanor is dismissed. Mrs. L.
Not for the people.
Mr. Harris.
Not from the defense, Your Honor.
All right, good luck to you, Mr. McLean. You're all
Thank
set.
you, sir. Thank you. No, have a great day.
All right. Who is the second one? Yates?
Yes, it's Mr. Yates, Your Honor.
Right, so we're on the record in docket 20-02461. That is People of the State of Michigan versus Guadalupe Yates. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Lethal, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Guadalupe Yates. He is standing to my right, Your Honor.
And sir, you are Guadalupe Yates, is that correct? Thank you. This is the time set for pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that we are still going through a sobriety court process here, some screening for that. The update that I've received from Mr. Harris is that there are some communication problems. We're getting some of that evaluation back. We are asking at this point for 30 more days to get that completed.
Yes, Your Honor, that is correct. When I spoke with my client, he indicated that the substance abuse assessment was completed and that a copy was going to be provided to me. I got in touch with, after not receiving anything, I got in touch with CMH, and the response I got from them was that according to them, Mr. Yates had filled out what they described as a consent form to speak when that CMH had asked him to fill out that would allow them to speak with me about the report, but there was a separate form they had not provided to him to actually release the form to me. I have now gotten that form. Mr. Yates has filled it out today, and I will be emailing that over to CMH once I have a moment today, so that I should be able to get that report. I imagine no later than a week from now. We would be requesting 30 days to get the report, go over it, and get my client screened for sobriety.
All right, and it's in that and the specialty court has its own rules. Yeah. I think they like to take the plea there, etc. Yes, so this has been processed for specialty court. The assessment's been complete, and it now has been is going to be released, and we will adjourn for 30 days. Okay, so it's almost at half a year. Yeah, so even our specialty court's getting a little, I have specialty court written all over the file from May 13th on. So I know the process that we're going through. It's slow. It's not supposed to be this slow. Okay.
Understood.
So we'll adjourn for 30 days too.
I have 3 weeks and 5 weeks, but not the 4 weeks, which is.
Let's try the 3 weeks.
August 12th at 9 o'clock.
August 12th at 9.
Yes.
Right, we'll adjourn for August 12th at 9 o'clock. The assessment should come through. I believe that sobriety court is, or the specialty court is Judge Buchanan. Or is that mental
I
health?
believe this, we were considering.
Is this 55th?
55th Sobriety Court in this case.
I thought
No.
it was 54B, but
Oh,
we'll
50.
figure that out.
All right.
Yeah.
It's off to one of the specialty courts, and we'll figure out which one. Mr. Harris, you have everything assessment wise for the release of the assessment.
Yes, I have a form filled out right here.
Perfect. Okay. All right. Anything else for the record in 20-2461, Mrs. Up?
Not for the people. Thank you.
Mr. Harris.
Not from the defense, Your Honor.
All right, Mr. Yates, we'll see you soon, okay?
All right.
All right, now, Mr. Woody, I'm gonna place you in room 1, and then I'll place, when your public defender, Mr. Harris, joins us, he'll also be placed in room 1. All right, sir?
Yes, that's fine.
That is People of the State of Michigan versus Peter Ding Majok. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Ned.
Representative APD and map my client standing to my right.
And sir, you are Peter Ding Majok, is that correct?
Yes, Your Honor.
Great, thank you. This is the time set for pretrial in the matter. Mrs. L, how are we proceeding?
Well, Your Honor, it's come to my attention that there is a new case in our referral in our office for Mr. DeMahok. Sorry if I say that wrong. This is a case of a similar charge, and it will be charged later today. I will be issuing those charges and working it through the system. At this time, the current case was supposed to be heading to a sobriety court referral. However, with the new case, I'm not sure if that's going to still happen. Since the case has been on the docket for 82 days, our position of the people would be to have this set for a final pretrial and potentially have the other case hopefully set the same day once it comes through. I know that can be challenging, but I do believe we'd be able to move forward individually if need be.
All right. So there is a pending, is it a pending drunk driving?
It is, Your Honor.
Okay. So there's a pending case that would take it out of the realm of specialty court. I know that this was looking at specialty court. And the request for the people is to set for final pretrial and then look at both cases together.
It would be, Your Honor.
All right, Mr. Ned.
So Your Honor,
And I don't know if you know anything about the pending case.
I missed the prosecutor for me earlier this week. We are aware of a pending charge. It's my understanding, I'm not confirmed that that incident happened prior to the one we're here for today. I could be mistaken. As an update with the court and the prosecutor, my client is currently being assessed with the 54B sobriety court. They've been in conversations. I saw emails as early as yesterday, I believe. They did the first interview yesterday. So I guess my question is, are we still looking at sobriety court? Should we just stop?
I don't know. I don't know if sobriety court will take him. I don't know with the
Correct,
pending,
Your Honor,
you know,
and I
that's the
believe-
problem.
It's good. I'm gonna assume it's gonna be a misdemeanor charge.
Yeah, but I think it's I think they go from a third, but see, I don't know how the pending would change that. And so I don't know, but sobriety court can take it or not, it did not take it, and they have their policies. So I don't know. I guess I don't know the answer. I don't know how the pending charge affects the current charge for sobriety court.
And I am slightly aware because I did handle the sobriety court. But again, it needs prosecutor approval. He would be eligible as long as the prosecutor agrees with it. So whatever the court and prosecutor wants to do.
Well, let's get the other case. Let's get it up and let's get it. So we're gonna build in an adjournment anyway because we have Mr. Ding Majok has to go see where he stands with sobriety court, and then the prosecutor's got a pending case. So let's set it for final pretrial. And we'll set for final, and Mr. Ned, you're indicating that the pending case may be prior to March 5th.
And I can speak on that, Your Honor. It is from an incident prior to that date.
All right,
However, it does make our office less inclined to. agree
right. I mean,
sobriety
it
court.
becomes a problem.
Correct. Your
Yeah.
Honor.
Okay, so let's set for final pretrial. Mr. Ding Majok, what I was looking at is if it's prior to the date, then we have to revisit bond. But since it's post that date, we have to revisit bond. This is prior, so I'm not going to revisit bond. Okay, you should be good. I think that you're on the right process. All right, you're on the right process. So we'll set for final pretrial. We have a pending case. We'll set for final pretrial probably 3 weeks out.
That should work.
Yeah, I would think 3 weeks out.
August 12th at 8:30.
All right, so we'll set for final pretrial on August 12th at 8:30. At that time, the second case can come in, get arraigned. You'll have to go through all that process, and then you can see where your specialty court, where that lies, and that'll give time for the prosecutor to evaluate both cases. Anything else for the record in 2501-089, Mrs. L?
Not for the people.
Mr. Net?
Yeah, thank you.
All right, you're all set. It's Ding Majok.
Ding Major, yes.
Majok, all right. You're all set, sir. Thank you.
Thank you, sir.
Your Honor. I am ready, or I am ready. And Savage. Yep.
Savage. All right, so we're on the record in docket 25-01898. That is People of the State of Michigan versus Ann Savage. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Lizelle, Assistant Prosecutor for the people.
Mr. Net.
George Jeanette APD on behalf of my client, saying, am I right?
And ma'am, you are Ann Morgan Savage, is that correct? All right, thank you. This is time set for pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that at this time we'll be asking for a final pretrial.
Is that a fair statement, Mr. Ned?
Yes, Your Honor, just earlier, my client was saying, am I right? She is currently in a wheelchair, just for the record.
Okay.
And we are prepared for final pretrial.
Right, we'll set for final pretrial on August 5th at 8:30. So Ms. Savage, unless I hear differently from the parties, that'll be live in person on the 6th floor, just like we're here today, on the 6th floor City Hall of Lansing, and we'll go forward for that as a final pretrial. Anything else for the record in 25-01898, Mrs. L?
Not for the people.
And Ms. Savage, you should get notice from my court office for that date. Anything else, Mr. Annette?
I gotta thank you.
You're all set.
Yeah, actually. That's all I have for right now. I'm gonna give Juanita Jones a phone call. She was
I'm right
supposed-
here.
Oh, there you go. We're ready on Juanita Jones.
Did you want, okay.
No, we talked earlier
All
this
right.
week.
All right, Ms. Jones. We can take, we'll take a break after Ms. Jones, unless Mr. Harries is back from. All right, so we're on the record in docket 19-04767. That is People of the State of Michigan versus Juanita Jones. Actually, I have two here. I also have, so did you want both cases called together, Mrs. L? I have both cases.
I believe they can be called together.
All right, because we have, so we're on the record in 19-04767. And then we're on the record in 20-03514. Mr. Ned, I don't know if you're on both of these cases.
I should be.
Okay. All right, that's People of the State of Michigan versus Juanita Jones. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Lizelle, Assistant Prosecutor for the people.
Mr. Ned.
George Jeanette, APD on behalf of my client, saying, am I right?
All right. And ma'am, you are Juanita LaShonda Jones, is that correct? All right, thank you. This is the time set for a pretrial on both matters, the 1-9 matter and the 2-0 matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that we're going to be asking for a final pretrial in both matters.
Is that a fair statement, Mr. Annette?
Yes, Your Honor. Let me just- Yes. Just for the record, Your Honor, I believe we are missing some discovery on both files.
On both files? And you'll
Yes.
make that known to the prosecutor
Yep.
concerning any discovery issues.
Other than that, nothing further, Your Honor.
All right, so we'll set for final pretrial on both 19-04767 and 20-03514.
August 5th at 8:30. We do not have an appearance on the 20 case.
So on August 5th at 8:30, we'll set both for final pretrial. And then Mr. Ned will need an appearance from your office on the 20 file, 20-03514. Or one is one may be filed and already in transit, but the computer doesn't indicate that the second appearance has been filed. But we'll set it for August 5th at 8:30. All right, ma'am?
Yes.
And you'll get notice by court officer. Anything else for the record in 19-04767 or 20-03514, Mrs. Al?
Your Honor, I would like to just ask for clarification from defense on what discovery they seem to be missing. In our records, discovery was sent in both files delivered to defense on June 25th of 2025. And it appears all discovery was sent on those
All right,
days.
so, Mr. Ned, do you know what discovery is missing from what file?
Yes, Your Honor. Well, I gave Andrew, in the MSP file, I only have one page of MSP police report.
That is 20-035.
And I also don't have any watch guard video. And the other file, I don't have any access on.
That's 19-04766. So the older file is 19-04767. And trying to see if that's an LPD file 19-04767. And your indication is you do not have on that file. What are you missing?
Axon.
Axon. All right, and then on 20-03514, your indication is that you have one page police report from the Michigan State Police.
Yes, sir. It's about 30 pages of discovery. A lot of it is like lab stuff. And in regards to the substance, it's only one page.
All right, that should get us started on discovery. And then Mr. Annette, you'll bring it to the court's attention if you're missing anything at the final pretrial.
Understood.
All right, anything else for the record in 20-03514 or 19-04767, Mrs. L?
Not for the people, thank you.
All right, Mr. Annette.
Okay.
All right, Ms. Jones, you're all set. Thank you for your.
Thank you.
Now this, Mr. Wood. So do you want to just set, what are we doing now?
I am ready on Mr. Woody.
All right, I can bring it back.
Breakout room, and then I also have Mr. Lira here before, I believe, 9:30, and I'm ready on that case as well, Your Honor.
Let's bring back Mr. Woody so we can. He's joining us from DOC. All right, Mr. Woody, we're ready to call your case. We're on the record in docket 25-01443. That is People of the State of Michigan versus Stephen Woody. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris, I'm here on behalf of Mr. Stephen Woody, who is joining via Polycom from the Michigan Department of Corrections, Your Honor.
And sir, you are Stephen Woody, is that correct?
Yes, Your Honor, that's true.
All right, thank you. This is the time set for a pretrial in this matter. Mrs. L, how we proceed?
Your Honor, it's my understanding that we're going to be asking for this to be set for a final pretrial.
That is correct, Your Honor. I've spoken with Mr. Woody regarding this case, and at this time, we would be requesting a final pretrial. Currently, he is lodged in the Michigan Department of Corrections on a parole hold. He indicated he should likely have a decision on that parole hold and on the alleged parole violations that are the basis of the parole hold. And he should have that sometime in the next week or two, maybe 3 weeks. Currently, his understanding is that is that the parole board is not objecting to him potentially being released to treatment. So we are, at this point, the prosecutor and I are going to be continuing negotiations to see if there may be some kind of resolution in this case involving him going to treatment, Your Honor.
All right, and so my understanding is that Mr. Woody may join us. I'm assuming for that final pretrial, we don't know if he's going to be in the Department of Corrections or out.
I think it's, at this point, I think it's reasonably likely he
Okay.
may.
So do you want to make that, so that's a live final pretrial?
All right. If the court would permit having him appear via Zoom, I think that might be.
I'm just wondering what the status, anyway, we get him here for the final pretrial.
I would have no objection to a Zoom final
Okay.
pretrial for Mr. Woody. I would still be still be asking the complaining witnesses to come in
Right.
in person.
Right.
But anything that's easiest for MDOC is fine.
So, Mr. Woody, you can attend the final pretrial. If you're out, you can attend in person, but you can attend via Zoom regardless. All right, sir?
Okay,
That just because we're uncertain where you're going to be. So Zoom is appropriate for whatever your circumstance, or if you go into inpatient, that may be an option also. But so we'll set
Okay.
the final pretrial for August 5th at 8:30. All right, so we'll set the final pretrial for August 5th at 8:30. Anything else for the record in 25-01443, Mrs. Zell?
Not for the people.
Mr. Harris?
Not from the defense, Your Honor.
All right, Mr. Woody, we'll see you on that August 5th date, and that is acceptable to appear by Zoom. Okay, sir?
yes, sir, I appreciate it, Your Honor.
Okay, you're all set. Thank you.
previous show, we have two up, I don't know if you're available. I can give one to Chad. They've had their stuff for quite a while, I'm gonna go grab one right now. Rand? You go. Oh, I'm sorry. You just get up here. What's the last thing? I will be signing.
on the iPhone, would you please identify yourself on the iPhone in the Zoom courtroom? No, I don't think they're connected to audio.
I can hear nothing.
Ma'am, can you identify yourself? And then you might want to, what's your name, ma'am?
Desiree Smith.
You're going to have to say that again. Desiree Smith?
That is my client, Your Honor. If I could have a brief breakout room with her, I would appreciate it.
All right, so Ms. Smith, I'm going to place you in a room with your public defender coming up in a few minutes. All right, ma'am?
Oh my God, I apologize. I apologize.
What's your name?
Desiree Smith.
So that's Desiree Smith. I don't know who. All right, so Ms. Smith, you're going to be placed in a breakout room with your public defender in a few minutes. I have
Okay.
you on here twice. You're using two. You're using two. Because I have you on Zoom twice.
Oh yeah, I thought something was wrong with my phone, so I tried to exit out, but I guess
All
it
right,
didn't.
all right. So Mr. Harris, when you join, we can put you in a room.
I believe I'm already in room one.
All right, all right. So Ms. Smith, I'm going to place you in room 1 with your public defender, and then we'll come back and put you on the record. And Ms. Smith will await Mr. Harry's appearance today, and then we'll place you on the record, okay?
Okay.
Apologies, Your Honor.
Mhm.
So let's go on Ms. Rogers and we'll go on, and then we'll go on Ms. Smith. All right, so we're on the record in docket 25-01118. That is people of the state of Michigan versus Caitlin Rogers. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izella, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Caitlin Rogers, who's standing to my right.
And ma'am, you are Caitlin Rogers, is that correct?
Correct.
Thank you. This is the time set for a pretrial today. Ms. Zell, how are we proceeding?
Your Honor, it's my understanding we are asking for a final pretrial in this case.
And is that a fair statement, Mr. Harris?
Yes, Your Honor, I've spoken with my client regarding the case and our options, and at this point, we would be requesting a final pretrial be set in this case.
All right, final pretrial will be set for
August 5th at 8:30.
August 5th at 8:30. So Ms. Rogers, they'll be live on the 6th floor City Hall of Lansing, just like today, and you'll get notice from my court officer, all right?
Okay.
Anything else for the record in docket 25-01118, Mrs. L.
Not the people.
Mr. Harris.
Not from the defense, Your Honor.
All right, I will see you on August 5th at 8:30. Thank you.
Thank you.
And Ms. Smith will call your case. All right, so we're on the record in docket 25-01908. That is people of the state of Michigan versus Desiree Smith. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izella, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Desiree Smith, who appears via Zoom, Your Honor.
And ma'am, you are Desiree Smith, is that correct?
Yes.
And you can hear me all right, Ms. Smith?
Yes.
Right, thank you. This is the time set for pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we're going to be asking for a final pretrial.
Is that a fair statement, Mr. Harris?
Yes, Your Honor, I've spoken with Ms. Smith regarding the case and the allegations in the police report, as well as our options going forward. At this point, we would be requesting a final pretrial in this case.
Okay, final pretrial date of
August 5th.
8:30. All right, Ms. Smith, you'll get notice sent to your last known address. We have Ionia. Is that still Ionia Street? Is that still a good address for you?
Yes.
All right. You'll get final pretrial set for August 5th at 8:30. Anything else for the record in 25-01908, Mrs. L?
Not for the people.
Mr. Harris.
Not from the defense, Your Honor.
So that'll be live in person on the 6th floor on August 5th at 8:30. We'll see you on that date. All right, ma'am?
Okay, thank you.
You're welcome.
Your Honor, I believe the only matter I have left that it's potentially too early for would be Jerry Porter. To the best of my knowledge, he has not checked in person or via Zoom.
All right.
I have tried giving him calls. However, the number is listed as disconnected or not in service, and we have no other methods of getting in contact.
And that was set for 10 o'clock.
Yes, I don't know how much more waiting will
Right. Well,
matter at this
if
point.
that's your last case, let's call that, because you don't have any 10:30s, Mr. Harris.
I do have, I have at 10:30, I have Arambula, Bryant, and Murphy.
All right, I'll leave it up to you. Do you want to wait on that? Or it's,
I will defer to the prosecutor.
okay. Mrs. Zelt, did you want to call the Porter case or defer it to call it last?
Your Honor, I would be okay calling that
All
last.
right.
For right now, it seems we have people here that are ready to go, so
All
get them
right.
out of here.
And it sounds like we do have Miss Arambula here, which I believe we would be ready to go on that.
All right. So are you ready to go, Mrs. L, on Miss Arambula?
I am, Your Honor. There is going to be a pink sheet for restitution that I will be filling out.
Okay.
Yes, we have reached a resolution in that case, Your Honor.
All right. All right, so we're on the record in docket 25-00513. That is people of the state of Michigan versus Christy Arambula. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Christy Arambula, who is standing to my right, Your Honor.
And ma'am, you are Christy Lee Arambula, is that correct?
Yes, sir.
All right, thank you. This is the time set for pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, the plea offer has been extended to defense through defense counsel. That offer would be to plead to an added count 2 of retail fraud in the 3rd degree under MCL 750.356D4, which is a 93-day misdemeanor and or a $500 fine. That would include an agreement to pay restitution in the amount of $269.34 to Meyer. Upon successful plea and sentence, we would be dismissing count 1, retail fraud in the 2nd degree. And there is a Killebrew to no objection in this case.
That is correct, Your Honor. That is my understanding of the offer. I spoke with my client regarding the case and the offer yesterday, and she advised that she is willing to, that she wants to take that offer and is willing to pay what the restitution necessary to make things right in this matter.
All right. So it'll be an added count 2 of retail fraud in the 3rd degree. That's a 93-day misdemeanor under $500 with a plea to count 2. Upon successful plea and sentencing, count 1 is to be dismissed. There is a Killebrew agreement of no upfront jail. So if I was going to do anything differently from that, you'd have the opportunity to withdraw your plea. Do you understand that, ma'am?
Yes, Your Honor.
All right, thank you. There's restitution to Meyer in the amount of $269.34. Do you understand that, ma'am?
Yes, sir.
All right. May I inquire of your, Mr. Harris, may I inquire of your client for advice of misdemeanor rights?
Yes, Your Honor.
All right. Miss Arambula, am I saying that right?
Arambula.
Arambula. Miss Arambula, you have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses are brought against you, to have the court order any witnesses appearing in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. You were represented today by Attorney James Harris. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You understand that? All right. If your plea is accepted, you'll give the claim the plea was a result of any promises other than what we placed on the record with threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial since you won't be having a trial. You'll be pleading guilty to the misdemeanor instead.
Yes, sir.
Is it still your wish to plead guilty to the misdemeanor instead?
Yes, Your Honor.
All right. Please raise your right hand. Do you solemnly swear or affirm? Tell the truth, the whole truth, or nothing but the truth under penalty of perjury?
Yes, sir.
All right. I'm going to bring your attention back, ma'am, to October 10th, 2024 at 6200 South Pennsylvania in the city of Lansing, Ingham County. Were you at the 6200 South Pennsylvania address in the city of Lansing on October 10th, 2024?
Yes, I was.
And that's generally known as Myers.
Yeah.
And did you take anything from the Myers store there that was offered for the sale to the public? I think it said $200 or less.
Correct, Your Honor.
Okay.
Yes.
What did you take, ma'am?
I'm gonna be honest with you, sir. I'm completely sober today.
Okay.
Almost 9 months. So I was actively using, and I do not recall, but I know I did.
All right. Do you have any
I know I did.
dispute that the allegation is that don't think they indicate the items, but there were items, multiple items, but your indication is that it was less than $200.
Yes, I did.
Okay, all right. All right, with that understanding, anything towards a factual basis, Mrs.
No, Your Honor, thank you.
Mr. Harris?
Not for the defense. Your Honor.
I would think that some value would be over $1.
Yeah.
Yeah, for the items. All right. So I find the factual basis to be knowing, voluntarily, and accurately made. Let's refer to probation. So we'll refer to probation. That's one floor down, all the way to the 5th floor. Because you've already made, it sounds like you've already made some steps.
Well, I'm an
concerning
adult
it.
circuit drug court in
Yeah.
Boone County, so.
All right, so let's take them, look at it, and they can do a report for me. We can
Okay.
find out a little bit of what's going on. I don't want to duplicate the probation, and that's the main thing. We don't want to duplicate.
Okay,
But let them prepare a report for me,
perfect.
and then we'll do a sentencing on
September 16th at 1:30.
September 16th at 1:30. So if you go down, they may see you now, they may set up an appointment. But what they'll do is they'll do a report for me, and we'll see what options are available to us.
Okay, perfect, perfect. Okay.
Anything else for the record in 25-00513, Mrs. L?
Your Honor, I just have a pink sheet.
All right, thank you. Thanks, Mrs. L. Mr. Harris, anything else for the record?
Not from the defense, Your Honor.
All right, Mr. Rambulo, we'll see you on that September 16th date, see what options are available to
Very
us,
good.
okay?
I do
Thank you so
apologize, Your
much.
Honor. Thank you.
Then, Your Honor, we are ready on the Trey Van Shake case. He is unrepresented today, but we will be dismissing for compliance.
All right. So let's go and call that, those two, we've got 2 files.
Correct, Your Honor.
Is he here today or?
Yes.
All right. So is that Mr. Van Shake? You can come up here. All right, so we're on the record in docket 25-01707 and 25-01707 and 25-01708. That is people of the state of Michigan versus Trey Van Shake. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Lizell, Assistant Prosecutor for the people.
And sir, you are Trey Van Shake, is that correct?
That's correct.
And you are not represented by counsel today, is that correct?
That's correct.
All right, thank you. This is time set for a pretrial on both of these files. Mrs. L, how are we proceeding?
Thank you, Your Honor. Today, both of these files are for a missing dog license for 2 different dogs. Today, Mr. Van Shake came in and did provide 2 valid licenses, 1 for each dog. At this time, we would move for dismissal of both cases.
Right, for compliance purposes, I will dismiss 25-01707 and 25-01708. Those were both, I think, so we're talking about the same dogs. It was Wutan and Pretty. Is that correct? All right. For compliance purposes, both cases are dismissed. Anything else for the record in 25-01707 or 708, Mrs. L?
No, Your Honor. Thank you.
Mr. Van Schack, do you have any questions of me? You should be all set. Thank you for your appearance today. I think we have Mr. Harry's cases.
Yes, Your Honor. I believe the remaining cases I have are Mr. Porter,
Okay,
and then I also represent Mr. George Bryant Jr. and Muhammad Murphy. My understanding is Mr. Murphy may be may be in custody. Mr. Bryant, I spoke with yesterday, and he indicated he would be here, so I do not know why he's not.
Mr. Porter's still not here.
And Mr. Porter is still not here.
So let's call Mr. Porter. And then,
Additionally, Your Honor, I will note on Murphy, I believe the request was going to be for a brief adjournment and then addressing the allegations of contempt.
all right,
He's not in custody, at least not,
but let's go. And then we have, how about Del Toro?
Mr. Del
Are you
Toro
Mr. Del Toro?
is here, yes.
All right. And that, I just have that as a probation.
That's fine.
All right. All right, let's go on Mr. Porter and then we'll go on Mr. Del Toro. All right, so we're on the record in docket 25-01397. That is People of the State of Michigan versus Jerry Porter. Appearances for the record, Mrs.
Thank you, Your Honor. Gabrielle Ellis, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Jerry Porter, who unfortunately does not seem to be here in person or via Zoom, Your Honor. I did try contacting him yesterday. However, when I called at the only number we have on file, that number rang as either disconnected or no longer in service. I have not been able to make contact with my client and cannot explain the failure to appear at this time.
All right, this was set for 10 o'clock. It's now 10:42. I do not see Mr. Porter in the Zoom courtroom or physical courtroom. Nobody answers by that name in the hallway. Based on the representations of counsel, we're going to indicate that the defendant has failed to appear for the pretrial that was set today. I have previous failed to appears. I have two of them, at least two. He failed to appear on May 27th of this year, and then he failed to appear on June 17th of this year. Mrs. Zell, how would you like to proceed?
Your Honor, that's what my records show as well. He has failed to appear for every pretrial we have set. Typically in a non-assaultive case, I would ask for a 48-hour hold, but based on the multiple failures to appear, I would ask for an immediate bench warrant.
Right, due to the not being in communication with counsel and two previous 48-hour holds have been placed, I'll issue an immediate bench warrant. Any comment, Mr. Harris?
No, I would leave that up to you,
Okay.
up to the court's discretion. At this point, I understand there are numerous failures to appear in the file.
All right, anything else for the record? So I'll issue a bench warrant for the non-appearance. Anything else for the record in 25-01397, Mrs.
Not for the people.
Mr. Harris?
Not from the defense, Your Honor.
All right, thank you. And then we have Mr. Del Toro. And I have that as a probation review. I have.
It's still with no contact.
Okay. I think he emailed.
Yeah, I'm going to Teams meeting.
All right. So go ahead and print that email off and let's call the case.
I don't know how to print it out.
Um, think that's,
Yeah, he messaged me and asked for a no contact.
all right.
I don't see.
And I think that's part of the. All right, so we're on the record in docket 24-02160. That is people of the state of Michigan versus Juan Del Toro. I think this was set by us. This is also. All right. And sir, you are Juan Del Toro, is that correct? Right, thank you. This was set on behalf of your probation agent, so we could revisit some of the conditions of bond. Why don't you tell me what's going, I think yeah, the request was to modify or lift the no contact order.
Correct.
And that is in regards to Amber Matthews, is that correct? Now, my understanding is that you had that, because you've got some children with Ms. Matthews, correct? And so we left it on for supervised contact with the children, and then this was set in order to revisit the no contact order. Is that a fair statement? Did you expect Miss Matthew here?
I didn't know anything. He just told me that, Ray Thompson told me that she had contacted him and saying something she wanted to.
All right. So what I'm going to do is I'm going to modify the bond at the discretion of Mr. Neves. All right.
Yeah, he said that there was any problems or any issues, just give him contact and he would let you know.
Okay. I think we set this because we were seeing, okay, there's no contact order. We took a look at the file. We're like, okay, there's children involved. And so we're being very careful with it. But we have an email from Mr. Neves indicating that he was contacted, indicating to lift the no contact order. I'm going to place it in the discretion of the probation agent, Mr. Neves, to modify the bond in regards to no contact. So that would mean that you can see the kids, and that would mean that you wouldn't be violated if that was the route that Mr. Neves chose. Okay. All right. So I'm going to indicate that no contact order can be modified at probation department's request. How's probation going otherwise?
It's going good. I mean, to me, it's just like a normal day. I don't do anything. I just work.
All right, and you're on probation till October, is that correct? And everything that indicated from Mr. Neves indicates that everything's going good. Okay, so we'll modify the no contact order. Probation will modify it at their request. And he's been in contact with the victim in the case, so he can make the modification, but I'll okay it. All right. Anything else for the record in 24-02160, Mr. Del Toro? You're all set, sir. Thank you for your appearance.
Appreciate you.
Thank you.
Have a good day.
You too. So whatever. All right. Mr. Carey, are you on Daracella? Ms. Williams?
No,
Okay.
I do not believe an application was filed.
Let's go. I
It
don't
was
think so.
filed, it was denied.
Yeah.
Oh.
Let's call those, Mrs. L, and then we can call the rest of Mr. Harry's 1030s.
Okay.
All right. So we're on the record in docket 25-01633 and 25-01634. That is people of the state of Michigan versus Daricella Williams. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
And this is the time set for pretrial in the matter. This was set for 10 o'clock. It is now 10:51, and it would appear that defendant has failed to appear for the pretrial. I do not see Miss Williams in the Zoom courtroom. There's nobody by that name in the physical courtroom, and there's been nobody by that name in the hallway. We'll call the hallway just in case. But it would appear that the defendant failed to appear for the pretrial. I have no prior bench warrants. There's a fail to appear for arraignment that was sent by paper, but she appeared late, according to the magistrate. So she was arraigned. This involves two dog cases, both from a ticket. Are they both from the same ticket? I believe so. Mrs. L, how would you like to proceed?
Your Honor, as I normally do in a dog case, if we could just do a courtesy reset.
So we'll do a courtesy reset for the pretrial. And we'll set the pretrial out for
August 5th at 10:30.
August 5th, 10:30.
Apologies, Your Honor, I was able to just get in touch with Mr. Bryant. He indicated that he is going to be joining Zoom
Okay.
right now.
All right, so we'll do a courtesy reset for Miss Williams on August 5th at 10:30 concerning both those files. Anything else for the record in 25-01634 or 25-01633, Mrs. L?
Not to the people.
All right, thank you. And then you said Mr. Bryant should be joining us.
Yes, Mr. Bryant should be joining via Zoom. And then if the court would like to call Murphy first, he does not seem to be here in person. And as far as I can tell, he's no longer listed in custody, either with ICJ or in any other facilities, according to Bryant.
I think Mr. Bryant just, all right. So let's call Mr. Murphy's. And we checked Fine Length and he's not incarcerated.
I did check Fine Length, Your Honor, and was not able to find any indication that he was incarcerated anywhere.
All right, so we're on the record in docket 25-01983. That is people of the state of Michigan versus Mohammed Murphy. This is set for a pretrial and a bond modification or bond violation. Appearances, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Mohammed Murphy for this case, Your Honor. Unfortunately, he does not seem to be here in person or via Zoom. And I did check the ICJ roster, and he is not showing in custody with in the Indian County Jail any longer. I did additionally check a Vine link to see if he was potentially incarcerated anywhere else, and there was no indication he was incarcerated anywhere else, Your Honor.
All right, thank you. This was scheduled for 10:30. It is now 10:55, and would appear the defendants failed to appear for the scheduled pretrial and bond violation. There's Mr. Murphy is not in the Zoom courtroom or the physical courtroom, and nobody is in the hallway. Last we checked, which was like 2 seconds ago. So it appeared the defendants failed to appear for the pretrial and the bond hearing. Mrs. L, how did you want to proceed?
Your Honor, at this time, we would ask for an immediate bench warrant to be issued. This case is an assaulted case. And additionally, the bond violation, which resulted in an additional case coming from Mr. Murphy, those are also based in arson, and we would ask that that be considered for this immediate bench warrant.
Mr. Harris.
I will leave it up to the court's discretion regarding an immediate bench warrant, Your Honor. I will note, I have also been assigned to represent him on the new charges. I believe they are set for next Tuesday with yourself, Your Honor.
Are the new charges of bond violation concerning the alleged at this time arson of the hospital?
Yes, at this point, I believe the new charges came as a result of the conduct that led to the bond violation in this case.
So I'll issue an immediate bench warrant concerning both the bond violation and the assault and battery, and then see if he shows up next week. Mr. Murphy is somewhat known to the court and also has a maybe homeless and in this regard.
Yes,
we're not sure.
Maybe I believe he may.
It appears that he may be homeless. So we'll issue an immediate bench warrant for the fail to appear on the assault and battery and the bond violation concerning this case. Anything else for the record in 25-01983, Mrs. L?
Not for the people.
Mr. Harris.
Not for the defense, Your Honor.
Thank you. And then did you want to speak with Mr. Bryant?
I am ready to proceed, Your Honor.
All right. So we're on the record. This is an unlicensed dog.
Yes, Your Honor.
We're on the record in docket 25-01253. That is People of the State of Michigan versus George David Bryant Jr. Will the parties please introduce themselves to the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. George Bryant, who is joining via Zoom, Your Honor.
Sir, you are, go ahead.
He apologizes to the court for his tardiness.
And sir, you are George Bryant Jr., is that correct?
Yes, sir.
All right. And you can hear me all right, Mr. Bryant?
Yes, I can.
All right, thank you. This is the time set for a pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, an offer has been extended for Mr. Bryant to take responsibility for a breach of the peace civil infraction. Upon taking that responsibility, we would be dismissing the dog license.
That is correct, Your Honor. I've spoken with my client regarding that offer, and he has indicated he would be willing to accept responsibility for that, and I would be accepting responsibility for that on the record, Your Honor. He has requested 60 days to pay the $150 fine, as he and his father, mom, and members of his family are currently experiencing a bout with homelessness right now after losing their homes. So he would request those 60 days to give him some time to get the money together to pay for it.
All right. May I inquire, this is a civil infraction. So is that a fair statement? That's your understanding, Mr. Harris? And Mr. Bryant, that's also your understanding. You'll be pleading responsible to the civil infraction, which is not the misdemeanor, and the misdemeanor will be dismissed. Is that right, sir?
Yes, sir.
Okay. All right. All right, so we're working from the same document for conduct occurred on April 24th, 2025 at Edison Avenue in the city of Lansing, Ingham County. Mr. Harris, you admit responsibility for your client being on breach of the peace on that day. Is that correct?
Yes, Your Honor.
And that'd be a fine of $150, and we'll set it for 60 days out. September 26th. All right, so Mr. Bryant, you have till September 22nd to pay the $150 fine. You can pay as much as you want or as little as you want as we go. as long as it's all paid by September 22nd. All right, sir?
Okay.
Anything else for the record? In 25-01253, the misdemeanor is dismissed without prejudice as a part of the negotiations. Anything else, Mrs. Zeller?
Not for the people. Thank
Mr.
you.
Harris?
Not for the defense, Your Honor.
All right, Mr. Bryant, you're all set. Thank you for your appearance today.
Thank you.
I believe that should be
I think
everything for the morning.
We're done. We've got some sensings in the afternoon and then a
Yes.
bunch of civil stuff.
Yes, I will note that I am the attorney of record on all of these sentencing.
All right, all the ones
So
that
I
we're,
might, I might request a little bit of
Yeah.
latitude or patience with.
right.
Absolutely not.
I think we're done.
Not allowed.
You'll be fine.
I'll give you as much time as you need, obviously.
Appreciate that.
Seems a little unfair, though.
How do you always end up with the bulk of the case?
I feel like it may be a leftover for when Mr. Lee was here.
It's just
And
luck.
And it seemed like usually Mr. Lee ended up with the bulk of the ordinance docket and I ended up with the bulk of the state docket.
Fair.
That's my guess at least.
Yeah, well, I have no complaints, so this is
Chuck?
Fachuk and Thomas. Thomason. Close. How are you girls doing?
Good, how are
How are
you?
you guys doing? Good.
Are you gonna check out that farmer's market today at the Capitol?
No, I don't think I am. I think I'm gonna leave that to the staff. And but I will check everybody's PBT as they come back at 2:30 because according to Megan, there should be like a tequila tent and things about the things.
No, that's not what I said. That is not.
Maybe
Right in front of the
maybe
Capitol,
Wendy
not
said
the-
that.
You
Maybe
know what, we should have a short afternoon there.
if you put that with the court staff, I don't think everybody's gonna PBT.
I don't even like
That
Your
way.
Honor,
tequila
I
for the
can
record,
tell you,
alright?
the only thing my blood is likely to test positive for after this is maple syrup.
Okay, that's a good thing. That's a good thing. All right, we'll see y'all this afternoon.
Up in the afternoon, put you in sobriety for maple. Kind of pancake addiction. We were muted.
It was windy. It was windy.
Actually, it was Roddy's idea to start with. Yeah, I don't even like tequila.
I like, yeah. All right, so we're on the record in docket 25-00583. That is people of the state of Michigan versus Damian Brown. Appearances for the record. And do you have a motion, Ms. Facha?
Yes, Your Honor. I'd like to make a motion 8.120 under the Michigan Court Rules to Practice. My supervisor is Gabrielle Azell. And my name is Andrea Fodchuk, Fodchuk.
All right, motion's granted, it needs to be made one time today. Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Damian Brown, who's standing to my right, Your Honor.
Thank you. And sir, you are Damian Brown, is that correct?
Yes, sir.
All right, thank you. This is the time set for sentencing in the matter. Ms. Fodchuk, any restitution in this matter?
Yes, we will ask that you follow the pre-sentencing report, which asks for restitution and costs.
Okay. On Mr. Brown, have fines and costs, but no, there is no additional restitution.
Yes, I
From
believe
the victim, is that correct?
restitution may have already been resolved and ordered, Your Honor.
All
I,
right. I don't see any, but the probation officer who wrote the report, Nathaniel Neves, had not received any restitution at the time. So so the people are just requesting fines and costs or something along those lines to follow the precedents. Is that correct, ma'am?
Yes.
All right, Mr. Harris, have you had the opportunity to go through the pre-sentence report with your client?
yes, Your Honor, I have. At this point, we do not have, I do not believe we have any additions, deletions, or corrections.
All right, allocution, Mr. Harris.
Yes, Your Honor, at this point, Mr. Brown is honestly apologetic. He doesn't have, well, he's apologetic. He realizes this was a rather unfortunate situation when he was, and I would simply echo a lot of the statements probation made in the PSI, that he realizes that he should not, maybe should not have been taking care of those dogs if they weren't his, and if he wasn't fully equipped and prepared to properly keep them secured on the property. He apologizes for the error. He is intent on taking full responsibility. I would simply request that the court follow the recommendation of probation and simply sends him to fines and costs at this time, Your Honor.
Ms. Fodchuk, any response on the sentencing, on the judgment of sentence?
None from the people, Your Honor.
All right. Mr. Brown, do you have anything to say to the court before the court passes the sentence?
Yeah, I'll probably just won't watch nobody's dog.
Okay. Probably a good idea. I have the defendant currently on probation to the same Nathaniel Neves. So I'm going to follow the recommendation based on Nathaniel Neves' pre-sentence report. This is for a guilty plea found on May 27, 2025 to the dog at large. The defendant is to spend 0 days in jail. Credits are given for 88 days previously served. I don't know if that's a typo or if that was on something else.
I think that was a typo.
Yeah, it's got to be a
My
typo.
apologies.
All right. How many days should you get credit for?
I believe 0.
Okay.
I don't believe there was anything listed on the custody section of the PSI.
Okay, so credits given for 0 days previously served, 0 days in jail. I'll have to make this look pretty because it's
Yeah.
fines and costs. That's really the extent of this. It'll be $100 fine, $100 cost for $200, $100 cost for $200. They'll separate it, but it's $200 fines and costs. Crime victims' rights fee of $75, state minimum court cost fee of $50 for a grand total of $325 to be made to the city of Lansing. And does your client need some time to make that payment, Mr. Harris?
Yes, Your Honor. Mr. Brown, how much time? You can ask for whatever time.
90 days?
We would ask 90 days,
All
Your
right.
Honor.
So it will make payment in 90 days to the city of Lansing. So as long as it's all paid by October 20th, you can set up your own plan before that, okay? So October 20th. And that would be $325 to the city of Lansing. And I'll write the same on the JOS, $325 to the city of Lansing by October 20th, 2025. Anything else for the record in docket 25-00583, Ms. Faulkner?
None for the people.
Nothing from the defense, Your Honor.
Thank you, Mr. Harris. You should be all set, Mr. Brown. This is the pretty one. All right. You should be all set, Mr. Brown. We'll see you, okay?
Oh, Mr. Brown, these are going to print out about the payments. The information on the payments. That's all the information you need regarding the payment charge.
Was I saying fuck man, it's Fod Chuck?
Bad Chuck.
Yeah. My fault.
Oh, it's okay.
Yeah. We want to get those things right. This is Mr. Brown.
We have successfully connected.
All right. So did you want to go on Mr. De Leon or?
I am.
Do you need some time to speak with Mr. De
I
Leon?
would need some time to speak with Mr. De Leon if we were going to be continuing with sentencing today.
Well, we have an interpreter here. But. Let's see.
I'm just afraid. Again.
Yeah, I'm afraid if we'll order another interpreter and they won't be here, but you need some time to go over the pre-sentence with your client. That's going to take.
Yes, I
some
am
time.
alternatively ready on Mr. Cornell, who's here in person, or Ms. Fiore Rosa.
I don't have any previous fail to appear for Mr. De Leon. So if he wants to come and. Yeah, we set this is the first sentencing set. And then, so if you want to adjourn the sentencing, have the interpreter here, we can put it all on the record right now.
I'll speak with him and see what you prefer. If you
All right,
prefer to go forward.
all right. So why don't you do that, Mr. Harris, and then we can. He's not.
You should be on Polly.
He's not. Yeah, he's in person.
Okay.
And there's no.
I responded to the email telling you perhaps he spoke with Mr. Harris. Mr. Harris is handling.
I don't know. I think all we're doing is waiting for the report. If I remember.
Your Honor, he's indicated he would like to have the sentencing resolved today, so I would be able to speak with him.
All right.
Or if the court would like to handle Mr. Cornell and Ms. Fiore Rosa first, I can handle those.
Let's go Cornell 40 rows, and then we'll give you the opportunity to speak to Mr. De Leon. All right, and this is Mr. Cornell.
Cornell.
You sir?
Good morning. Good afternoon, I should say.
Yeah, good afternoon.
All right. And Mr. Harris, do you know anything about the Castillo case?
The Castillo case, I am actually going to be covering that for Mr. Hardy.
That's what we thought.
My understanding.
You're just
is
waiting
that-
for a report?
Yes, is that we haven't received any report. There hasn't been anything provided. So Mr. Hardy was asking if I could stand in to request an adjournment to get that.
Do you expect Mr. Castillo here?
I am not sure, Your Honor. My last understanding of Mr.
I think he's
Castillo was that they were
incarcerated.
in custody.
Yeah.
So I guess leave that up to the court to indicate whether or not.
I just never know if Polycom's going to put him on or not. So, let's let's wait till it's all done and we'll go from there.
Understood, Your Honor.
But that. All right, so we're on the record in docket 25-00670. That is people of the state of Michigan versus Blake Cornell. Will the parties please introduce themselves for the record?
Andrea Fodchuk for the people.
Thank you so much.
You're welcome, Your Honor.
And Assistant Public Defender James Harris here on behalf of Mr. Blake Cornell, who is standing to my right, Your Honor.
Thank you. And sir, you are Blake Cornell, is that correct?
Yes, sir.
Right, thank you. This is the time set for a sentencing in the matter. Ms. Fodchuk, do you know of any further restitution? I have of $120 Ingham County prosecutors cost recovery and $100 to the MSP on this matter. Do you know of any restitution, formal restitution in this matter?
No, Your Honor, that is an accurate description of the restitution for this case.
All right, Mr. Carries, have you been able to go through the pre-sentence report with your clients?
Yes, I have, Your Honor.
Any additions, deletions, or corrections?
At this point, we do not have any additions, deletions, or corrections.
All right, allocution, Mr. Harris.
Yes, Your Honor. When I spoke with Mr. Cornell, he indicated that he has been doing just about everything in his power possible to try and to ensure that an instance like this never happens again. Since the original incident, which I believe was back in 2023, he's been participating he's been going to support groups and to AA. He's been participating. He has multiple pages worth of proof that he provided to me today. He also has his father here in support of him. And as his father himself had advised me that he had previously had an issue with alcohol, his father has also been providing help and support to Mr. Cornell as someone who has already gone through a lot of the same things Mr. Cornell has been going through. He advised me that he is willing to comply with the term of probation. He is willing and ready to participate in the programming that is recommended. Your Honor, I believe that Mr. Cornell will not only succeed, but will likely succeed with flying colors in terms of probation, as the vast majority of the things probation is likely to ask him to do are things he has already been doing without any order of the court requiring him to, simply because he simply does them because he wants to better himself, or he wants to become a healthier person who does not have these issues and who would not repeat this conduct. At this point, I would be requesting that the court follow the recommendations of probation. I would request if the court would consider ordering perhaps 6 or 8 months of probation rather than the full 9 that was recommended, as I believe Mr. Cornell has already been doing most of what would be required of him by probation for far longer than the past 9 months. And I would argue that at least some of that dedication and attempt to improve and become healthier is worthy of some recognition and some statement on the record. So I would ask if the court would consider lowering the term of probation from 9 months to 6 or 8 months. And then finally, Your Honor, regarding fines and costs, I would request that the court could consider ordering more minimal fines and costs so that Mr. Cornell can focus his finances towards any programming probation is recommending and towards the MSP and cost recovery fines as well. Thank you, Your Honor.
Thank you. Mrs. Fodchuk,
Yes.
any response to Mr. Harry's allocution?
We the people believe that we would like to ask the court to stick to the PSI in accordance to its recommendations of the 9-month probation.
Thank you. Mr. Cornell, is there anything you'd like to say to the court before the court passes sentence?
No, Your Honor.
Thank you. This is for, I'm going to stick with the judgment of sentence. I'm going to tweak it a little bit, but it is the judgment of sentence. Some is for the recovery costs. I'm gonna do things a little different just to even it out. and then put you on a smaller term of probation only because this is a recognition that you've already done some things towards it. Really, all this is, and I want you to take advantage of district court, is district court now, as it should, is providing you resources so you can see if this is a one-time occurrence or if you have a problem with alcohol. If there's a problem with alcohol, we all have the same problem. So then you understand that you've got to have a productive relationship, not a destructive relationship. That's kind of ongoing. It sounds like you've already taken those steps, all right? So you understand most people come in front of me because they drop dirty, okay? I'd say that's probably 80% is what, 80% is probably dropping dirty. And so this is your chance to show off a little bit, okay? To really show off, to drop clean, and then I'm not involved in your life and you're not involved in coming here. You must have something better to do on a Tuesday afternoon with your time.
Actually, today is my baby's 3-month birthday.
All right. So that speaks for itself.
I've moved to better myself for not only my son, but to show my dad that, you know, he did make a mistake, but I'm gonna prove him that it can be done.
It can. You also have people who love you who depend on you.
Oh yeah.
And that creates a great responsibility. It's also a lot of value. There's a lot of value there. So this is for the OWI that was found guilty on April 29, 2025. I'm going to indicate that you are to spend 30 days in jail. Credit's given for 1 day. I'm going to suspend the remaining 29 days. So all the time, there's no upfront jail. Fines and costs, I'm going to set fines at $100, costs at $100. So for $200, so it'll be $200 fines and costs. Crime victims' rights fee of $75. State minimum cost fee at $50. Ingham County prosecutor recovery at $120. Probation, I'm going to set for 6 months. So that'll be 6 times 30 is 180. And then the MSP amount for $100 for the restitution to set it at, and I'll give you a grand total. And this can be paid over the course of probation. So that's 200 plus 320 plus 125 plus 120 plus 180 plus 100. I have 725 in total.
Sure.
That's 100 MSP, probation 180, that's 280, 3, 400, 525, 6, 725. Probation for 6 months via Zoom, pay $30 a month. And then comes all the restricted behavior you've already started to take part of. So no assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription, submit to random PBTs, enter a urinalysis as directed by your probation agent, who looks like it'll be Jody Bayless. Submit to random PBTs and urinalysis. No bars or nightclubs is a good idea. Complete following rehabilitative services, pay fees, and provide proof of completion of the court. I'm going to order outpatient substance abuse as you recognize that. Attend the victim impact panel within 90 days with verification. And I'll tell you why I usually do that. I usually do that because it's good for people to hear that this could happen to anybody, all right? That this is something that all of us should hear, that all it takes is one extra drink and then to get stopped. And all of a sudden you're in a range of, well, something happened to me that I never thought would happen to me. It's good for people to hear that, so that they can question whether they should have an extra drink or two when they have to get into a car, because there's ways around it. I think that's good for them to hear that. Obtain and maintain employment. Not purchase or possess firearms, ammunitions, or dangerous weapons in the 6 months you're on probation. Do you have any questions concerning the judgment of sentence, Mr. Cornell?
No, I do not. And I did have another firearm prior to the situation. After I got arrested, I did forfeit my firearm over to my father.
All right.
So just a quick question. After the fact, after I'm done with probation, I'd be able to get that firearm back, correct?
I think it was forfeited as a part of the.
No. Not the one that I
Oh,
forfeited.
the second one? After probation, you're fine.
Okay.
Yeah.
And then it was just a quick question, because if I had to forfeit that one as well.
No,
I'd have had him.
just the one related to the negotiations.
Okay.
All right, so So you're good with that farm as soon as you're done with probation.
Okay.
All right. I will, first of all, we'll make it look pretty.
And to confirm, Your Honor, I believe Mr. Cornell's probation officer is actually Joe Sumter. My
Perfect.
understanding is Ms. Bayless may have done the report because I believe this was prepared when Mr. Sumter was
It's
out.
on FMLA.
Yes.
Yeah, I happened to actually meet him in person the day before he was about to give birth. 'Cause
Right.
my woman was having some issues, so.
He's a pretty easy guy to work with.
He was
Yeah.
cool. He was
Yeah,
like.
he's a very nice
If
guy.
you see me, he was like, "What are you doing up here?" I was like, "Hey man, I'm just up here for the woman. That's all. She's having some issues." He's like, "Yeah, not gonna see you, brother." He's like, "I'll see you when I get back." But
No, he's very easy to work with for the most part. So you know you know who you have to contact in order to keep. He's the only one who would violate you. Okay.
Yes.
All right. Anything else for the record in docket 25-00670? Miss Fachuk.
Not for the people, Your Honor.
Is that close?
Yes.
Okay. Mr. Harris.
Not from the defense, Your Honor. Thank you.
You're all set, Mr. Cornell. Thank you for your
do
appearance.
I have to wait for paperwork?
No, I think you should be, if you want to stop by and see
probation
Mr.
officer?
Sumter, just to make sure you're on the same page.
Okay, I
Okay.
just don't know. It's because I know I have to get like stuff for like the drops and all that, and all the
Yeah.
classes.
That, you probably should talk to Mr. Sumter.
All right,
All right.
appreciate it.
You're all
You guys have a
right.
wonderful week.
You're all set.
Thank you. You have a good day.
Then we have,
Next.
did you want to go on Ms. Fordiso and then you can
Yes, Ms.
talk to
PRD
Ms.
Rosa, yes.
No, it's kind of. I just-
All right, so we're on the record in docket 25-00927. That is People of the State of Michigan versus Janine Fiordiso, Fiora Di Rosa. You can protect, you can correct that. Appearances for the record, Mrs. Fachuk,
Andrea Fodchuk on behalf of the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Miss Janine Fiordirosa, who is appearing via Zoom as she currently lives in Arizona, Your Honor, and is appearing via Zoom with the court's permission.
Correct. And ma'am, you are Janine Fiordirosa, is that correct?
Correct.
Thank you. And you can hear me all right, Miss Fiordirosa?
Yes, I can hear you perfect.
All right. All right, this is the time set for a sentence in the matter. And Ms. Fachuk, is there any restitution in this case?
No, Your Honor.
Mr. Harris, have you had the opportunity to go through the pre-sentence report with your client?
Yes, Your Honor, I did provide the PSI to my client and she had a chance to go over it. We discussed if there are any questions, and I don't believe from the email discussion we had that there were any questions, Your Honor. Additionally, I believe the only correction that needs to be made is that the PSI indicates that she was moving to, I believe it was
Illinois.
Yeah, Illinois. She actually moved to Arizona, and I believe that updated address was provided to the court. I believe the only real change might be that probation may need to find a different program for her to go through, as I'm not sure if the Haven Wave program is, I'm not sure if that was recommended based on being in Illinois or not.
I'm not sure. Because I have an older address. I have an Oakwood, Ingleside, Illinois address. We need an updated address.
We have no updated information. We have
All right.
nothing indicating she was in Arizona.
So, Ms. Fiordirosa, do you have an Arizona address we can update the file with? And then we'll have to make sure that the probation, any terms of probation are conducted through Arizona.
Okay, yes, I will give you the address. And when I
All right.
spoke to him, he said Arizona would be fine. I would just have to locate drug testing centers since he's not familiar
Correct.
with Arizona.
So, yeah,
Okay.
that you spoke with that came from the probation agent, Mr. Neps.
Yes, and at that time I was in Illinois.
All right. So what's the updated, just for a court file, what's the updated address in Arizona?
It is 13820 South 44th Street. That's unit number 1171 in Phoenix, Arizona 85044.
All right. All right. And then this will have to, the probation, if I follow the probation order, would go through anything that you find that Mr. Neves finds appropriate through because this is for domestic violence. So it would go through the whatever probation arrangement is made, especially in regards to the alcohol or drugs, right, ma'am?
Yes.
Okay. All right. Because I think he ordered it, but I don't know if we had the same probation understanding since Illinois was the state and then it went to Arizona and he still had to make sure that everything was on board. Mr. Harry's allocution on the matter.
Yes, Your Honor. Every time I've spoken to Fiorderosa, she has been apologetic and she's been trying to get this issue resolved. She is rather aware that this issue may have stemmed from a rather toxic relationship she had, which is part of the reason why she ended up moving out of the state, to have a clean break so that she can essentially, a clean break from the more toxic elements in her life and the elements that likely would have resulted in things happening the way they happened here. At this point, she is willing to participate in probation, and probation seems willing to give her that chance to try and resolve this. I would be requesting that the court follow the recommendations, Your Honor. I will note.
I think Haven is an Illinois program.
I believe the Haven program was recommended as an Illinois program. I would recommend that probation, either with my client or for my client, finds a similar program she can participate in Arizona. I do not believe there will be any concerns about any violations for contact with the complaining witness in this case. Is part of the reason she moved out of the state to Illinois, then Arizona, was to have a clean break from this person and essentially cut all contact, no longer have them in her life. So I would be requesting that the court follow the recommendation. I will note that on the probation recommendation sheet filled out by Mr. Neves, there was not the box for granting or denying consideration under 7694A special status was not marked. I did confirm with Mr. Neves over email regarding that, and he stated that that was an oversight, and that he had no objections to 7694A, and that he believed my client would qualify for that status. I did also speak with the prosecutor, and the prosecutor indicated they would have no objection to my client being given that status, as it was part of the plea agreement in this case. So I would be requesting that the court grant 7694A status on this, special status on this case. Finally, regarding any fines and costs, I would simply request the court order relatively minimal fines and costs to allow Ms. Fiorderosa to put any resources she has towards the programming she would be participating in over in Arizona, Your Honor.
All right. And from the people, I have a kilobrew of 7694A status. So is that a fair statement concerning the kilobrew agreement?
Yes, Your Honor.
All right, so for for the guilty plea of May 13th, 2025. In the no contest plea, it is ordered that you spend 29 days in jail, credits given for 1 day previously served. I'll suspend the 29, so there'll be no upfront jail in this matter, ma'am. Upon successful completion of probation, and then probation will be ordered via Zoom for 9 months. Because that was left open. 9 months. No contact with, so 769-4A is granted. That's really carrot in this instance. It's abstracted differently as for law enforcement purposes only. So it won't appear as a record for regular purposes. So that's really the carrot here. So over the course of probation, I'll set fines and costs, $100 fine, $100 cost for $200. Crime victims' rights fee of $75, state minimum cost fee of $50, and probation for 9 months at $30 a month, for a grand total of $325 plus $270 to $325. That equals $595, and that can be paid over the course of the 9-month probation. The 769-4A as previously indicated is granted. No contact with the victim, Brandon McLittle, or be within 2,000 feet of where a victim lives, works, goes to school without consent of this court. No assaultive or threatening behavior. No use of possession, alcohol, marijuana, or controlled substance. The probation is okay via Zoom. Submit to random PBTs, enter your analysis as directed by your probation agent. We'll talk about that because we're going to get you set up in programming so Arizona can do some of that, all right? The programming. And no bars or no nightclubs. I'm going to strike Haven domestic violence. So complete the following rehabilitative services, pay fees, and provide proof of completion of the court. I'm going to strike the Haven domestic, and I'm gonna indicate any similar program out of Arizona.
Confirm, Your Honor, were you ordering random PBTs and or your analysis?
I'm gonna kind of leave that to the discretion of the probation agent.
Okay, I wanted to confirm
because I don't know if out of Arizona it would be the same. So I'm afraid I'll leave it to the discretion just to see, because Mr. Neves is gonna have to contact somebody in probation out there who's gonna have to monitor, and that's 3 or 4 issues away from the typical, maybe 2 issues away.
I simply wanted to check, Your Honor, because on the PSI, I did not see that box checked, so I didn't believe that was being recommended.
I am going to order it, but that's really in the discretion of Mr. Neves, okay? I will iterate that I did not see drugs and alcohol were involved over the situation. Okay. So that'll be there. That can be implemented at the request of the probation agent, but it's truly at his request. He's also got to set up something with the Arizona probation, probation department. Otherwise, that's why I'm putting that language in. I believe domestic violence is more appropriate, and since the Haven was set specifically, any similar program to Haven should suffice for that programming. All right, ma'am?
Would it have to be a 26-week class?
It does not. It does not. As long as Mr. Neves indicates it's similar in nature, it doesn't have to. The length of it doesn't matter. Because I just don't know what's out there in Arizona.
Okay, thank you.
So any similar program at direction of probation. Not purchase or possess firearms, ammunition, or weapons of any kind, and obtain and maintain employment. So over the course of 9 months, you'll be via Zoom on probation to Mr. Neves. I'm looking at this as a learning experience, Miss Fiore Rosa. So that kind of the less we see each other, the better. Make sure Mr. Neves knows how that you're in contact with each other, knows that you're on probation. he is the person who would violate you, okay?
Okay.
Any questions concerning the judgment of sentence, Mr. Harris?
Not from the defense, Your Honor.
All right, any questions concerning the judgment of sentence from the people?
Not from the people, Your Honor.
Ms. Fiordorosa, do you have any questions concerning the judgment of sentence or anything I've ordered today?
Is there a chance, like, if I do really well, that like probation could end sooner or anything like that?
It's a DV, so it can't end in half the period of time, but I would entertain from Mr. Neves, if he believes that under the 9 months have been ordered and he believes that probation has been taking place, I'll wait to hear an email from him. I'll kind of leave it in his discretion. It can't be cut in half because it is an assaultive crime.
Okay.
All right. You should probably check in with Mr. Neves just to make sure you understand the nature of how to contact him. He would be the person who would violate you. Okay, ma'am?
Okay, thank you.
All right. That's all for the record in 2500927. Anything else, Mr. Harris?
Not from the defense, Your Honor.
From the people.
Not from the people, Your Honor.
You notice I'm just saying the people because I've been butchering your name left and right.
It's okay.
Ms. Fiordorosa, you're all set. Thank you for your appearance.
Thank you.
Yeah, we should make it pretty because that one's kind of a mess. It's Mrs. Fachuk,
Yeah,
but I'm never sure, so,
it's okay.
all right. And then, Mr. Harris, did you want to go on Mr.?
I would need to speak with Mr. Estileon first, Your
Okay.
Honor. Or I could, I guess, go on Mr. Castillo.
Let's see.
It's really up to you. Let's go Ms. Castillo. Yeah.
Understood.
What's that? Oh, Carlos might. I forgot. Carlos is right there. Let's go on Mr. Daly. So I'll put you.
I can go speak with him regarding.
All right,
the,
perfect. Take Carlos with you because.
Yes.
Fury Rose. He was, I saw him there, but I didn't act on it. Marquita, is there anything you need?
Can I holler at your JA real quick?
Sure.
Okay, wonderful.
Only if I get to holler next.
Oh, yeah, absolutely, absolutely. Hey, honey, I have a question.
We had 4 free trials.
And Judge.
Oh, we did today because Judge had to speak.
It's, well, this year is. 9.
Today was Thursday.
I know, but what I want to make sure that I'm doing. We just had one. We don't keep, it's like the record retention, so I can send my record.
Of course.
Even though it's like.
Couldn't find my email.
Oh, okay.
And I have been reading court rules last hour. I'm tired. My eyes hurt.
So for
It's 6 years. It's like, and it says it in there. I just was rereading it to make sure.
especially if the
Yeah,
transcript.
I mean, well.
One case is found over,
Did you
so
read this before?
there had to be one.
Back then, they were only required to be produced.
Oh, you can read.
If one party or the other asked for it. It wasn't until, I believe, 2018.
About
2018 that it be, whenever the public defender's office came into play. is when-
2021.
That's when they became mandatory.
I think it was 2020.
No, it was before
it was
COVID.
So Mrs. El-
So 2019 maybe.
Let's have you spell your name. Okay,
Right now,
yes.
F
F
O
So I'll just keep using that. I just wanted to make sure.
C
H.
H U K.
And what's your first name?
Andrea.
we've already done a trial together, and I want to make sure we're doing this right. Andrea Fodchuk.
Yep.
And then your intern. It's Thomason, right?
Yeah.
Okay. So say your first name.
Laura.
Laura. And Thomason.
I'm just like.
Thompson. So THOMPSON.
Yeah, because we just did it, so I just wanted to, thank you, honey. Appreciate it.
I'm cheating, but I'm telling you, I'll forget. Then it'll be a problem.
Well, I'll only be here till August 1st, so it's my understanding that Ms. Thompson will be in our court for the fall.
All right, okay.
I mean, more fun.
Well, as Mrs. L knows, it takes me time. It just takes me.
She is really excited. We have a defendant coming up with his first name spelled EZAL, and I'm like, oh, that's gonna cause some confusion that day.
You know it will, you know. I was just getting used to Miss Wilson. And then, and that became constant, and then she left, and then so yeah, it takes me some time.
We're gonna keep you on your toes.
Yeah.
Your turn.
I'm all out. So.
Can you mute us while we wait for Mr. Harris?
Yeah. All right, Mr. Smith, you're here on 1801709. That's LAFQ.
I am here on behalf of LAFCU. Which case are you calling, Your Honor?
It's Williams, Miss Williams.
Oh, Camira. Okay, gotcha.
All right. Let's call that because I know she's here. We have a break in the action, and let's while we have it, let's use it. All right, so we're on the record in docket 1801709. That is LAFQ versus, is it Camira? Chimera Williams. Will the parties please introduce themselves to the record? Mr. Smith.
For plaintiff LAFCU, Tim Smith, P48259.
And ma'am, you are Chimera Williams, is that correct? Is that a yes, ma'am? Yes. All right, thank you. This is the time set for a discovery matter in this proceeding. I'm assuming, Mr. Smith, that, and then you can tell me if I'm wrong, it would work best if I swear Miss Williams in, place her on an iPad, and then you can indicate what information you need in this discovery proceeding. Would that be a fair statement?
It is, Your Honor. Can you just give her, I don't want there to be any, we had a phone call back in shortly after she got served, and maybe if the court explained that I'm going to be asking questions about her financial situation and other personal information, and she is required to answer those questions in a truthful fashion, as well as produce documents relating to the information that is being questioned?
I think you just heard it, and that's pursuant to the Discover proceeding. That's why we're here, okay? All right, so I'll swear you in, and then my court officer will find you some privacy, put you in an iPad, and I'll put you both in a room, and then we'll come back and put it on the record, okay? All right, please raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right,
Thank
if
you.
you follow Miss Slaviak, she'll place you with an iPad with a room, and we'll give you some privacy. All right, Mr. Smith, you should get a prompt to go to room 1, and then I'll place the iPad in the same room once it becomes available.
Thank you.
All right. And then this is Mr. De Leon.
Yes, Your Honor, we are ready to go.
Is that on the sentencing or on the adjournment?
On the sentencing, the client wishes to handle the sentencing.
All right, so Carlos, I'll have you. What would we do without Carlos and Glenn? There's some questions.
Maybe we'll never know.
Let's hope. All right. So let me swear you in. Please state your first name and last name and spell them both for the record. Carlos.
First name Carlos, Carlos, last name Hernandez, Hernandez.
All right. Please raise your right hand. Carlos, do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications, so if you got under the penalty of perjury?
I do.
All right. Let's put the iPad in. Mr. Smith, okay. All right, Carlos, just let me know if I get going a little fast.
Will do.
All right. So we're on the record in docket 25-01031. And that is people of the state of Michigan versus Francisco. I have US De Leon or us De Leon. Appearances for the record, Ms. Thompson.
Laura Thompson on behalf of the people, and I'd like to motion to practice under Michigan Court Rule 8.120. My supervisor is APA Gabrielle Ezel.
All right, that's granted. Mr. Harris.
Assistant Public Defender James Harris for Mr. Ustelio.
And sir, you are Francisco De Leon. Thank you. This is the time set for a sentencing in the matter. And Ms. Thompson, is there any further restitution on this matter from the people?
There is not, Your Honor.
All right. Mr. Harris, did you have the opportunity to go through the pre-sentence report with your client?
Yes, Your Honor, and we have no additions, deletions, or corrections.
All right, allocution of Mr. Harris.
Yes, Your Honor. In this case, Mr. Ustelio does take accountability for his actions and for letting his emotions get the better of him, as well as the potential for alcohol playing a part in this case. He is willing to participate in any probation programming. And I have spoken with him about the random PBTs and anger management class with Cristo Ray that are being recommended by probation. I discussed with him the concerns probation has about programming, given him only speaking Spanish. However, probation does seem willing to give him a chance, and there does seem to be an anger management program with Cristo Rey in Spanish. My client I also spoke with him about the concerns regarding the no contact order, since both parties live in the same apartment complex. My understanding, well, I have spoken with him regarding what that no contact order means. And that he would be not allowed to have any contact, direct or indirect, with the complaining witness. Mr. Usteleon indicated that he understood and would endeavor to have no contact. And will avoid the complaining witness to the best of his ability to abide by the terms of probation.
That is Andrea Garcia.
I
think that's the complaining victim. I think we already lifted that no contact.
Oh, wonderful.
Yeah, at the request of the complaining victim, we modified that and it was lifted on April 29th.
Thank you, Your Honor.
And that's why it has not been ordered, I don't think. All right. You may proceed, Mr. Harris.
I also spoke with my client about the Scram alcohol tether for 90 days recommendation. My understanding is he already has that set up and running, and he is willing to submit to that for 90 days. I would be asking that the court follow the recommendations and grant the 769.4A special status. And regarding fines and costs, I would request the court order minimal fines and costs to allow Mr. Usteleon to put his resources towards program.
Anything towards the sentencing from the people, Ms. Thompson?
We would ask that the recommendation be followed and we agree to the 769 4A status.
All right, and Mr. U.S. De Leon or us De Leon, is there anything you'd like to say to the court before the court passes sentence?
Not at this time, Judge.
All right, this is for the no contest plea for April 29th, 2025. I see the ideas that Mr. Neves has placed in to try to kind of see what resources are available, but also make them available to Mr. De Leon in concerns with any translation that we might have. So I'm gonna follow the recommendation. I'm gonna tweak it a little bit in terms of some items, but I'm gonna follow the recommendation. So this is for the guilty plea on April 29, 2025. No contest to domestic violence. The defendant is to spend 33 days in jail. Credit is given for 3 days previously served. I'll suspend the remaining 30 days upon successful completion of probation. So there'll be no upfront jail. I'll set fines at a minimum of $200. Fines $100, costs $200, $100. Fines $100, costs $100 for $200 fines and costs. Crime victims' rights fee of $75. State minimum cost fee of $50. Probation at 8 months at $30 a month. And then there's the MSP fee. So that'll be 200 plus 125 plus 240 plus 100. And that's $665. And that can be paid over the course of probation. Placed on probation for 8 months via Zoom is acceptable. $30 per month as oversight. And who wrote the report is not exact. I don't know who you're on probation to. Jody Bayless wrote the report, but that may not mean that Jody Bayless is the investigator. I'm granting the 769 4A status per the Killebrew agreement. And then I'll set the following conditions of, and this is, I see what Mr. Neves was trying, at least Ms. Bayless was trying to do, was trying to put the programming that she thought would work, okay? So complete following rehabilitative services, pay fees, and provide proof of completion to the court. I think that's the anger management group at Cristo Rey.
Yes, Your Honor. That is my understanding.
So complete that and make sure your probation officer has a certificate of completion. And then the other thing that you've already started to work on, you're going to be placed on Scram alcohol tether for 90 days. And then that's going to be reviewed internally, whether you need to stay on for more than 90 days, but just for the 90-day period, you'll be on Scram alcohol tether. Right, obtain or maintain employment and not purchase or possess a firearm, ammunition, or weapon of any kind. Anything towards a factual basis, considering anything towards the judgment of sentence, pretty much following the order. I think the only thing I changed was the days in jail, no upfront jail. I don't think I changed anything else. And the fines and costs, Mr. Harris.
Right. Nothing from the defense, Your Honor, just to confirm. Was the court ordering random? I don't know if I missed.
I did not order any random PBTs because I figured that the alcohol tether for 90 days was sufficient under the guise of what the probation agent has put together.
Understood, Your Honor. Thank you.
Oh, you should, we won't, yeah, not use, possess, or alcohol, marijuana, controlled substance without prescription is checked, but the PBTs are not. I'm assuming the Scram alcohol will go off if that's a problem. All right. Anything towards anything towards the judgment of sentence, Ms. Thompson?
Not for the people, Your Honor.
All right. Mr. Russ De Leon, do you have any questions concerning the judgment of sentence for me?
Not at the moment.
All right. I would go down to see who his probation agent is, just to make sure he's on the same page. You might want to take Carlos with you, just to make sure that he knows who he needs to contact. All right, and then you can tell him that, Carlos. We can make that look pretty too, the minutes. All right, anything else for the record in 25-01031, Ms. Thompson?
No, Your Honor.
Mr. Harris?
Not from the defense, Your Honor.
All right, Mr. De Leon, you're all set. Thank you for your appearance today. Mr. Hernandez, thank you for your assistance.
Yes, absolutely, Judge. Pues ya está todo listo, ellos están mejor, usted de acuerdo, vamos abajo y abajo, a ver si consigo.
Let me give you, let me tear it down.
Yeah, I'm not trusting that.
So get yelled at.
The first time will be the last.
Yeah. All right. And then did you want to go on Mr. Castillo?
I think we can, Your Honor.
You can, Your Honor. Your Honor, would the court prefer to go on the record, or would the court prefer me to bring Mr.
Did we need you, did we need an interpreter on Castillo?
No, we did not, Your Honor.
All right, so you can go, if, did you want to go down with him?
I could.
Or did you want to wait?
I can go down with him if that would be.
I don't think you have to, but somebody should go down with him just to make sure he knows who his probation agent is. Right? Thank you, Mr. Hernandez.
Yes. Thank
And I think Megan's already going too. But I think we need Carlos there anyway. All right, so we're on the record in docket 22-02201. That is the People's State of Michigan versus Alexander Castillo. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Bell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harry, standing in for assigned counsel. Assistant Public Defender Joseph Hardy, on behalf of on behalf of Alexander Castillo, who I do not believe, who is currently in the custody of the Union County Jail.
Yeah.
I believe we would be waiving his appearance.
Yeah, and are we waiving his appearance today, Ms. Ezell?
We are, Your Honor.
All right, he isn't, I have him last incarcerated and he hasn't been placed on polycom, which comes as no surprise, but that's his reason for non-appearance. All right, with that understanding, it is my understanding that we are awaiting a report to be done for Mr. Castillo. This was set as kind of a control date, something we'll do again, just in case. But we're awaiting a report to be done for Mr. Castillo. Is that your understanding, Mrs. L?
That is my understanding, Your Honor.
I think the packet was done by Mr. Woolley. Mr. Hardy.
June 18th.
On June 18th. And yeah, I don't see it in here. All I see here is a petition for referral, but I have no date. But we've set it for today's date. Mr. Harris, is that your understanding? We're waiting for a report, and Mr. Castillo is in the Ingham County Jail, waiting for the report.
Yes, that is my understanding, Your Honor.
Okay. So we're waiting for the report to be done. On competency. And we're here on June 17th. That was when the original order, we signed the competency affidavit on that time, and we're waiting for a report. I'm assuming 30 days out, or that would be my best guess, because at that hearing, we're gonna have to decide what we're gonna do. Because then he's incarcerated, and I think this is a probation violation. So I think it's a 1-year offense that he pled to. Yeah, no contest to ag DV. So it's a 1-year offense. So in the next 30 days, we'll wait and see, and then we'll decide what we're going to do. Because if we don't have a report yet, we should at least, has he been evaluated? Do we know, Mr. Harris?
I do not. My understanding from Mr. Hardy is that is that we did not have a report, and to his knowledge, the Center for Forensic Psychology is a bit backed up and working through.
It would be my guess that there's not even been an evaluation.
That would be my
That
best
would be
guess.
my guess. So, all right. Well, you know where the court stands. I'm going to wait 30 more days. And then if I think a 60-day period, we can start determining what we want to do concerning what buttons to push concerning getting a report done and getting it prioritized. Because although this is a probation violation, Mr. Castillo should have some sense of finality in this, I would think. All right. So we'll set it for 30 days out for control dates for mental health review or forensic review. And we're in that vicinity.
August 26th at 9.
All right, we'll do August 26th at 9 o'clock, and you can share that date with your colleague, Mr. Harris.
Yes, Your Honor.
All right, anything else for the record in 22-02201, Mrs. L?
Not for the people.
Mr. Harris?
Not for the defense, Your Honor.
All right,
Thank
we
you.
should be all set on Mr. Castillo's case. Thank you for your appearance today.
Thank you.
All right. All right, Ms. Williams, you can come up here. Mr. Harris, thank you for your assistance. Ms. Williams, Ms. Tossman, with Ms. Thompson, and Ms. Fodchuk, who's not here. Thank you for your assistance this afternoon. All right, so Mr. Smith, we're back on the record in 1801709. You had the opportunity to speak with Ms. Williams in a breakout room on an iPad.
I did, Your Honor. I anticipated it was going to be difficult. We did not get through the Q&A. The exam got off the rails. If we could just have some direction from the court towards the defendant that we just need to listen to my questions, answer my questions, we can get through this process, give you time to produce documents, and we can get this thing completed.
So there seems to be a problem with the meeting, Ms. Williams. Were you able to answer any of the questions that were posed to you?
It's not that I can't answer his questions, Your Honor. It's that he can't seem to hold his smart remarks. Every time I mention something, oh, well, that doesn't make sense. We're adults. Please act with professionalism.
All right.
I'm not a child. I need for you to speak with me in the proper manner, just like I'm speaking to you.
All
if
right.
I'm saying something to you, there's no reason for you to follow back with a smart remark. I'm
So,
not a child. Please
Were
don't do
were we able to answer the questions?
I was answering his questions, but every time I answered his question, he had a smart remark
All
afterwards.
right. So, Mr. Smith, she indicates that there was some problem with communication. Did you want to try this again, or do you just want to set it for another discovery hearing? I say we do that live on the record, and we could do that live in person, so that you ask the question, and then I'll ask the question, and she can make answers. And that may work better if we're all here. Or do you want to try? Do you want to try the discovery hearing? We could put her back on an iPad. It's entirely up to you.
If we do it live, Your Honor, then all this financial information is public. I would prefer to do it in a breakout room. I just have a few more questions left. There's no disrespect, or we just need answers to the questions. That's what we need. So
all right. If you're able to answer, so I'll put you on an iPad. If you're able to answer the questions, fine. If you're not able to answer the questions, fine. We'll get through the process, and then we'll go from this discovery proceeding. This is, I believe, this would be set for pre-trial by the civil department, or we passed
This is
it?
post-judgment.
Post-judgment, okay.
So we would just reset the discovery.
Okay, all right. So let's do that. Let's put you back on an iPad, answer the questions that we can get through this, and then we'll go from there, all right?
As long as he can hold his remarks,
All
I'm
right.
fine, Your Honor.
All right, so I'm gonna have you go back to Ms. Slabiak, and we'll place you back in room 1. The iPad's already there, and Mr. Smith, you can rejoin room 1.
Thank you, Judge.
Thank you. And then on the OnePlus GNN cell phone, can you please identify yourself? on the One Plus GN 2200 cell phone. Can you please identify yourself?
Tawana Jurdo.
Tawana Jurdo, you're here for your
Yes.
3 o'clock with
Yes.
Mr. Bucci, is that correct?
Yes.
All right. And then Mr. Akanicki, you're here on that case?
Yes, Your Honor.
All right. So let's, so the One Plus GN is Tawana Jurdo.
Yes.
And then on the TCL 2702Z, could you please identify yourself? The other cell phone? You're under the moniker of TCL T702Z. What's your name? You just unmuted?
Yes, Robert Watkins.
Robert Watkins. And
Yes.
you're here for your 3 o'clock.
Yes, sir.
All right. So opposing counsel's not here on your case, Mr. Watkins. So I have a prospective order on that case. So we'll stand by on that case. Mr. Akanicki, you have a 56-day motion. Did you want to meet with Ms. Jurdo, or did you just want to go forward on your motion?
I'm happy to talk to her and see what her side of the story is, Your Honor.
All right. You can explain to her the purpose of the motion. All right. So, Ms. Jurdo, I'm going to put you should get a prompt to go to room 2 to speak with Mr. Akanicki, and Mr. Akanicki will also get a prompt to go to room 2. And then, Mr. Cox, are you here on the Frankenmuth case?
Yes, Your Honor.
Okay. And I know Mr. Watkins is here, so let's go ahead and call that case. I've got to bring that up because this is.
Watkins should be, I don't know, never mind. I don't know.
It's on
base.
On base, yeah. 1-7 and I have 1-7 and 1-8. I don't have 1-4. So nice try. Your case. So Mr. Cox and Mr. Watkins, we'll call your case.
Yep.
We're on the record in 1-4-0-9-3-8. That is Frankenmuth Mutual versus Robert Watkins. Appearances for the record, Mr. Cox.
Good afternoon, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
And sir, you are Robert Earl Watkins. Is that correct?
Yes, sir.
All right, thank you. This is the time set for I have an objection to installment plans, and then I received, Mr. Cox, and you can make a record if you want, but I received a installment order regarding installment payment plans that has not been signed by myself, but that was a pending order for this hearing. Mr. Cox, did you want me to where do the parties stand on the order regarding installment payments?
Yeah.
Mr. Cox?
Plaintiff didn't submit a proposed order. Plaintiff's position is that it's not necessarily objecting to the entry of an installment payment order. Plaintiff would like the defendant to begin making installment payments. However, the balance outstanding on this judgment, which dates back 11 years, is just under $6,700. And so plaintiff, in its response, indicated we thought it should be something more like $175 monthly, just because I think by our calculations, even maybe even exclusive interest, it's on a 6-year plan. So we were hopeful that the amount might be something more commensurate with the amount of the judgment balance, not so much that he shouldn't be afforded the right to pay in installments.
All right. Mr. Cox, did you want the opportunity to speak with Mr. Watkins concerning this order regarding installment, just to explain to him some of your position on the matter before we actually go to the motion for installment payments? I think Mr. Watkins is proposing $100 a month, which would set it at a 6-year or more plan.
I mean, Judge, if he's agreeable to 150, we can enter an order right now.
All right. So, Mr. Watkins, did you want to speak to Mr. Cox, or because it is essentially I'm looking at your order, the order that you made ex parte, and then Mr. Cox would have to agree to that order, or would have to say that there's no objection to that.
Yes, I will agree to the 150. I can do that.
Okay.
We can do the 150?
Yeah, Judge,
All
I
right.
can stipulate on the record 150 a month, and then we can pick a date, maybe within the next 30 days, where the defendant can begin making installment payments, and it doesn't matter to plaintiff which day he picks in the next 30 to start.
All right. If that, I will, for the record, I can cross out the 100 every month starting August 8th and make it 150 a month starting August 8th. Would that suffice, Mr. Cox?
Sure. If the defendant wants to keep it at August 8th, we can have it then be the 8th of each month thereafter. If he wants to move that around a little bit, all the way up until maybe even August 15th, I would be agreeable to that as well.
Mr. Watkins?
Yes, sir.
So would you prefer to pay $150 starting August 15th or August 8th?
Yep, I prefer August 15th.
All right, so I will do the $150 and I'll initial it starting August 15th. And that would suspend any garnish requirement. That'll just start $150 at August 15th. Is that a fair statement, Mr. Cox?
Yeah, Judge, it is. We don't show any periodic garnishments outstanding, so
Okay.
I don't think there's anything that need to be suspended based on the entry of this order, but it is fair to say that we cannot move the court for a garnishment against wages as long as this order remains in effect.
All right, so I will check box 4 that the defendant will pay $150 every month starting August 15th per the agreement of the parties. And then I will sign the order to that effect. Am I good to sign that order, Mr. Cox?
Yes, Your Honor.
And Mr. Watkins, is this part of the agreement that's to your understanding?
Yes, sir.
All right. I will sign the order to that effect. And then we will be responsible for signing and scanning it into the system. Is this, let's see, 1-4. All right. So we'll sign and scan it into the system, and then we'll provide a copy to each of the litigants. All right.
Okay.
Very good. Judge, would it be possible for me to go into a breakout room with Mr. Watkins for 2 minutes?
Yes.
So I can walk through the means by which he can make payment, how to make payment, and the options he has in that regard. I don't want to put it on the court record, boy, Your Honor, with that. So if I could speak to him briefly, that would be great.
So, Mr. Watkins, you're gonna move to room 3. You should get a prompt to go to room 3.
Oh.
And Mr. Cox, you'll also get a prompt to go to room 3, and then you should be all set.
Very good.
All right, Mr. Smith, we'll call case 1801709. And Mr. Smith, were you able to conduct and finish the discovery hearing with Ms. Williams concerning this matter, Mr. Smith? Mr. Smith. There he is.
Sorry, Judge. We did complete the Q&A part of the examination, some difficulty. There are some documents that are responsive to the court subpoena. They relate to two employment relationships, a couple different banking relationships, and a vehicle registration. Taxes aren't really involved because she hasn't filed in a couple of years. I'm going to get in writing to the defendant, reminding her what she needs to send and where she needs to send it. And we're going to give her 30 days to get physical copies of that through the mail to my office.
And then if there need be, we can set another discovery hearing, or we can show cause her for the material, but we can set it, but you're looking at a date 30 days out. Is that correct?
That is correct, Your Honor. I anticipate we're going to need that date in follow-up.
All right. So we'll set it. So he's going to send you what he needs. That email is going to send you with a list of any discovery materials. We'll set it out 30 days. You can attend via Zoom if you want, okay? But we're going to set 30-day continuance of the discovery hearing for whereabouts. I'd go past 30 than earlier than 30. So we're July 22nd today.
September, that would be helpful, just so I can plan ahead.
And some of it's just what's already been scheduled, but I think we were in that vicinity.
September 9th at 2:30.
September 9th at 2:30 for the continuation of discovery if need be. And Mr. Smith, you can let us know if we need that date, and Ms. Williams will give you notice so you'll have it before you leave. All right, ma'am?
I'm typing it out right now.
All right, so it's September 9th at 2:30 for a continued discovery if need be. And my court officer will give you notice. Anything else for the record, Mr. Smith?
Nothing, Your Honor. Thank you.
All right, Ms. Williams, you should get notice from my court officer. You're all set. Thank you for your appearance tonight.
I have a question.
Sure.
The paperwork that I apparently need to bind, I need to talk to a clerk. Do I go to the clerks that are right out there?
The civil clerk, you probably go to the civil clerk,
Yes.
which I believe they're on the floor below.
The floor below.
Yeah, 5th floor.
Okay. Thank you.
You're welcome.
Your Honor, I had two other matters at 2:30. I don't think either party has shown.
Yeah, let me see. So I think you're right. I do have one finished. 1-4. All right. So let's go on the 2:30. I have you, Mr. Smith, for a 2:30 and a 3, and it appears they're both not appearances.
Correct.
All right. So let's go on 1-3. So we're on the record in docket 13-02023, Lansing Automakers versus Lonnie Van Noller. Appearances for the record, Mr. Smith.
Plaintiff Lapku, Tim Smith, P48259.
All right. This is the time set for a discovery hearing. It would appear that Lonnie Van Noller has failed to appear today. Let me see when we. So, Mr. Smith, how would you like to proceed concerning the non-appearance of Lonnie Van Noller concerning this matter?
We'll prepare and file a motion to show cause, Your Honor, we'd ask that service be by 9-day mailing. There was personal service effectuated in this particular matter, and we'll prepare and submit that.
All right. All right, I will indicate that this was scheduled for 2:30. It is now 3:16, and it would appear Alani Van Aller is not in the Zoom courtroom or physical courtroom or in the hallway. So the defendants failed to appear today, and I will entertain a motion for show cause concerning the non-appearance. And you will submit that for the court's signing. Mr. Smith, is that correct?
That is correct, Your Honor. Thank you.
All right, thank you. That's all for the record. Let me put order to file. That's all for the record in docket 1302023 GC. And then, Mr. Smith, if you give me 1 second, I'll call your second case.
Thank you, Judge.
And then we're on the record in docket 1702780. That is Last Q versus Kristen Johnson. And this was set for motion to show cause. Appearances for the record, Mr. Smith.
Plaintiff Latvieu Tim Smith, P48259.
All right, this was set for show cause. Ms. Johnson failed to appear for the discovery proceeding. I do not see Ms. Johnson in the Zoom courtroom or physical courtroom. She's not in the hallway. This was scheduled for 3 o'clock and it is now 3:18. So for the fail to appear for show cause, Mr. Smith, how did you want to proceed?
To bench warrant, Your Honor, for bond consideration purposes. It's a small balance on this one. There's a little bit left after some payments have been made, but the balance remaining $577.31. So we'd ask for bond in that amount on the warrant, and we can prepare and submit.
All right. All right. So bond will be signed for that amount for the fail to appear show cause in the amount due, which is just over $500. And I will sign that upon presentation. So the orders to follow, and the bench warrant will be issued with that amount. Anything else for the record in 1702780, Mr. Smith?
Nothing, Your Honor. Thank you so much.
All right. You should be all set, Mr. Smith. Thank you for your appearance today.
Thank you, Judge.
And then we're on the record in docket 2408836. And that is David Bush versus Tawana Jurdo. Appearances for the record, Mr. Akanicki.
Good afternoon, Your Honor. Robert Akanicki, attorney for the plaintiff.
And ma'am, you are Tawana Jurdo, is that correct?
Yes, sir.
All right, thank you. This is time set for, it's commonly referred to as a 56-day motion, or at least that's what I refer to it as. Mr. Akanicki, you had the opportunity to speak with Ms. Jurdo in a breakout room, is that correct?
That's correct, Your Honor.
All right. How did you want to proceed today?
Your Honor, I think I need to move forward on the motion. I did talk to Ms. Jurdo, and I understand her point of view, but I think based on my client, I need to move forward with the motion.
All right. You may proceed, Mr. Akanicki. I did have the opportunity to read your motion, so so be aware of that.
Thank you, Your Honor. Well, Ms. Jurdo has been a tenant for a long time, and my clients worked with her several times, and she's always managed to catch up. This time she has been paying some future rent, but has failed to catch up on the past due balance. So at this point, my client would ask that the order of eviction be reissued so he could enforce it. I informed Ms. Jurdo that he would still have 56 days before he enforced it, but there was no promise that if the court re-entered it, that he wouldn't enforce it immediately. But at this point, I don't have any authority to try to work with her any further. So I would just ask the court to grant the motion.
All right, thank you. And then Ms. Jurdo, do you have anything in response? You understand that it's once I sign the motion, it's within the discretion of Mr. Bucci where this goes and how this eviction goes forward. but you understand this is after 56 days, they have to file a motion to reinstitute the case, and that's what they're doing. Do you understand that, Ms. Jurdo?
Yes.
All right. Do you have anything in response to Mr. Akanicki's motion?
Other than what he said, I've been trying to keep up with the current rent and pay the back rent as well.
Right.
I can only give him what I can, what I have extra, and I'm assuming that's not good enough, or it's not making up enough for him, or in a quick enough pace.
All
I
right.
can only
So
give him what I can.
I understand, Ms. Jurdo. So I'm going to grant the motion for 56-day rule to reinstitute the CADE and I will grant the motion, and then you'll follow that up with an order, Mr. Akanicki, and then you can talk to the property manager, your client, and they can go from there.
I'll do that, Your Honor. Thank you.
All right. All right. So I'll await the order to follow. I'll grant the motion for 56-day rule. Anything else for the record in 24-08836, Mr. Akanicki?
Nothing for me, Your Honor. Thank you.
Ms. Trudeau, do you have any questions of me?
With this ruling, so like, do I know how long I got? It'll be at his discretion.
You'll reinstitute the case. The order of eviction it would be in the discretion of Mr. Bucci. Once I sign the order, which will be in the next couple of days. How many days from the order from once the order is signed, Mr. Akanicki?
Well, Your Honor, what will likely happen, Mr. Jurdo, what will likely happen is we'll probably provide the order to a process server immediately, and they'll probably post it, and then they'll reach out to Mr. Bucci and see if he really wants a full eviction, if he wants it enforced. He could say yes, that would happen in a few days, or he could say, well, wait, and I don't know what he'll do, and you can talk to him about that, but that's the process.
Right. And so the discretion after the order is posted really lies with Mr. Bucci.
Okay.
All right. Is that a fair statement, Mr. Akanicki?
Yes, Your Honor.
All right. All right. I'll sign the order when presented. Thank you, everybody, for your appearance today.
Thank you.
Thank you.